We are live right now. So let's see who jumps on. But anyway, guys, this is an impromptu special episode of We the Parents. My name is Chris Cole. I'm normally the host of this. But I wanted to talk to you guys today about my story, especially what's just gone on in the last few weeks in my story. So what I did was I brought on some friends in the movement, some attorneys that are both going through their own personal legal battles, as well as Connie Reguli, right? I said it right.
Yeah,
Reguli,
regulate.
like regulators.
Right.
I'm going to let Ted and Sean and Connie sort of host this show. My mom is down below. I have her muted because she's going to join in the conversation. But guys, do me a favor, and I'm going to remind you constantly, look down below. It says share, follow, subscribe. If you can just share this anywhere that you can share this, that would be helpful. And if you feel like subscribing after that, that's great. But Ted Bush, I'm yours, buddy.
Well, thank you, Chris. I'm going to strive to be as good an interviewer as you are, because I've told you many times that I think you have natural talent. So while everyone else is joining, I thought I would sort of leave a preemptive message for our friends in the judiciary and potentially your opposing counsel, Chris, because we're about ready to talk about some of your case. And I wanted to preface this so when they first log in and they watch this episode, that they'll be able to know what some of the law in the First Amendment is. And I wanted to, just start off, just as an appetizer, if you will, of bringing to your viewers' attention the case of Bridges versus State of California. That was the United States Supreme Court in 1941, in which some petitioners had been found guilty of contempt of court and fined by a California state court. And their convictions rest upon comments pertaining to pending litigation that were published in newspapers. So this is 1941. This is before the internet. So what did our wise Supreme Court state in vacating these convictions? This is a quote from the United States Supreme Court from 1940. Okay, 41. A lot of famous justices on that bench. Quote, "The assumption that respect for the judiciary can be won by shielding judges from published criticism wrongly appraises the character of American public opinion. For it is a prized American privilege to speak one's mind, although not always with perfect good taste, on all public institutions, all. And an enforced silence, however limited, solely in the name of preserving the dignity of the bench, would probably engender resentment, suspicion, and contempt much more than it would enhance respect," end quote. Isn't that something? Okay, and I'm actually reading from an Illinois case that then goes on to quote Thomas Jefferson. That Thomas Jefferson indicated that a distasteful press is preferable than no press at all. So, but with that being said, for everyone who might tune in later, such as your opposing counsel, and the others that like to follow you, Chris, would you mind, stepping in as now actually a guest on your own show and tell us what happened in the last 24 to 48 hours?
Thanks, Ted, and thank you, Connie and Sean and Mom and Cecilia for being on this broadcast. So just in the last 24 hours, I was hit with a ex parte order and a motion for emergency custody. That's just in the last 24 hours. I was supposed to have my kids this weekend. However, that was interrupted due to this. This was done, in the 11th or 12th hour, or whatever the expression is, as her attorney has always filed motions. It's always on my weekend, and I receive things in the mail or by email on Fridays when I'm supposed to get my kids, which is, if I'm being honest, is sort of an emotional roller coaster slap in the face when I'm trying to enjoy my children. And, I don't have them for 12, 13 days at a time. And at any point they can file these motions, and if I got them in the mail and it upset me a little bit, that would be fine. But it would give me some time to recompose myself when I have my children on my only weekend. I see my children 4 nights a month. So I sort of think that's a little unethical, rude, and sort of harassing. And that's my opinion. But that's the last 24 hours. In the last few days,
Mm-hmm.
I received a CPS investigation.
So, a second, Chris. Let's just go back a little bit farther. Now, didn't you just conclude in your case a long parenting time hearing?
Yes.
But that was about what, 6 weeks ago?
So we had a hearing. Yeah, it was about 5 or 6 weeks ago where I represented myself, and I was granted no more custody than I have now, other than they added some holidays and weekends. And they wouldn't grant me any summertime. And the judge that was presiding, it wasn't my original judge. He went on vacation. The judge that was presiding that day pretty much ignored everything I had to say. Nothing was included as facts and findings within the court order. Anything that I presented as facts and findings.
Right. So just a second. So you had a stand-in judge replace your standing judge, come in and sit and hear an entire custody trial, basically a modification. You filed a motion to modify your judgment. There was never actually really a judgment. So how many days of trial did you have in that proceeding?
It was scheduled for 2. It lasted about 1.5.
So you spent 1.5 days with a completely different judge,
Mm-hmm.
traveling in from another country or county who you've never met before, has no idea who you are, and is now hearing your entire case.
Correct. He's actually from another county and retired. He lost his last election, I think, in 2014. In the other county that it was in. So he wasn't an elected judge. He's retired, but apparently he was brought into Alamance County sort of to give vacations.
All right. And we can talk about this, Judge, later. I just wanted to give a quick overview until we get into this. So you spent a day and a half in trial where everything is up effectively. When you're filing a motion for a modification, virtually anything can come in.
Right.
Correct. Right. Now, so then today, who entered the ex parte emergency order protection? Which judge?
The judge that signed the ex parte order at 4:04. It was clocked in at 4:04 at the clerk's office, which I should have gotten my kids prior to that. But this was all done right before I pick up my kids. And that was signed by my original judge, who wasn't present during my hearing.
So the judge who was on vacation, while a day and a half of testimony was heard in your case where everything was on the table, he comes back without having any clue of what happened a few weeks ago, and then slaps an EOP on you.
Yes.
Okay. Now we have one of the best, the best. I know Diane Redleaf is from Chicago, Connie. You are our hero. So I wanted to get into some of the CPS stuff. So please stop me at any time and just cut me off. I will mute myself without hesitation, because
and I would like to say something about the ex parte orders, because ex parte orders, which for the audience that doesn't understand that lingo, because we like to use Latin, and so that you don't know what we're talking about when we practice law, and we can just keep you confused, right? So an ex parte order means on behalf of one person only. So that everybody totally understands this, basic due process, basic constitutional due process is notice and the right to be heard. Okay, so those two things you need to be able to have jurisprudence and to be able to have due process, procedural due process. And an ex parte order is when one side can go to take a piece of paper and write something on it and take it to a clerk's office and have it filed and attach an order to it and tell the judge that everything is true in what they have written down and filed with the court under oath, and therefore there's an immediate risk of harm. And that is the only time an ex parte should be used. I mean, and it should only be used if, I mean, you have a child who's in some horrible shape. I don't know. Chris hasn't talked about yet what they actually put in that petition. But, this is the very same thing that put my client in jail when they created this ex parte that they filed at 3:45 in the afternoon after I had been spending 3 and 4 days trying to contact people. And hers was a CPS investigation, but I called and left messages for workers and supervisors and regional and detective, and nobody would call me back. I called the clerk's office. Nobody would call me back. And at 3:45 in the afternoon, they had filed an ex parte order, and they went similar in a little bit different manner, but the same as Chris. They went to another county and got another judge to sign the ex parte order. And so it reeked of constitutional violations. And as a result of that, what they did created great injury for that child, just as you have here with Chris. The injury here is to the children. And I don't know, Chris, I don't know personally, and you need to fill us in a little bit as to what you're talking about here. I think you're talking about one child. I don't know how old. I don't know, a boy or girl. But if it's any child who has an expectation of going to see a parent, and then that is crushed, you are creating complete chaos in that child's mind. And then I want to say there are several dads that I've gotten to know who have been fighting these just egregious situations where every time they keep trying to change things and the judge keeps shutting them down. And when I was in college, I studied psychology, and, we talked about how do you make a rat crazy, right? Well, you randomly shock it, right? You just no rhyme or reason. You just randomly shock the rat, and you're going to make a rat crazy, right? So, that's what I'm hearing kind of in Chris's situation. This is the other part that just drives me crazy, because judges have way too much power. They don't pay attention to what they're doing. They have no idea of the damage, the emotional, psychological damage that they're doing to the children and the injured parent in this case. So, I'm appalled, and I hate this, and I've seen it for 27 years, and it's not fixed yet. We need to outlaw ex parte orders. I say, if you're a bad enough person that they can arrest you for child abuse or neglect, they need to go get a criminal warrant and pick your butt up. And I'll tell you why. Because if somebody files a false affidavit for a criminal warrant on you, and then it gets dismissed, you can go charge them with civil rights violations, but you can't do it in these domestic cases.
Well, Connie, I just had a trial last week. Everyone knows who Cash Jackson is, and it was a trial of Cash Jackson. And we went back to the very beginning, and the very first EOP entered into his case. We got his ex-wife on the stand testifying that her divorce attorney was waiting outside the domestic violence courtroom while she went into the judge by herself. So this was 2 weeks before the petition was filed, and these attorneys were not filing appearances into these OP cases and letting women go in, or men possibly, go in by themselves to the judge when in fact they were represented by counsel. I mean, that's literally, and these are the leaders in Illinois against shared parenting. So, well, I mean, while we're sort of on Connie's expertise, Connie, I'm sure, is much more involved in medical neglect issues involving DCFS and CPS. That has exploded. But Chris, what sort of happened with you is that this looks like to be more like a form of medical neglect. Only they're accusing you of intentionally doing something. What are you accused of intentionally doing, Chris?
I mean, essentially what it is I'm intentionally giving the children things that they're allergic to because I don't think they're allergic. That's false. Everything in this motion is false. Basically what had happened was I spoke with their mother and we talked a little bit about their allergies. I'm never privy to any doctor's visits. I'm always having to call the doctor and they fill me in afterwards. I don't know when the last time my kids even had an allergy check. Although I did speak with my ex just a few days ago before she filed with CPS, and she's trying to twist things. And, I was told by her and by my kids that they have had the two allergens are peanuts or peanut butter. I guess it's peanut allergy for my oldest. And for my youngest, it's a protein milk allergy. It's not lactose, but it's a protein in cow's milk, I believe specifically. This is all I know. This is secondhand information from my ex. I've not been to the doctor with her. I don't know when they go. It's always, hey, we went to the doctor. This is what you need to do. And a lot of times when I speak to the doctor, it's not quite what I need to do. It's not quite the reality of things. And I spoke with the doctor today, read her some of the things that were in this motion for emergency custody. And she stated, if any of that was true, we would have had it on our records, and possibly I would have been notified because it's to protect the children.
Well, let's just stop for a second. So were you accused of intentionally giving your children allergic food that they're allergic to?
Yes.
Now, Sean, you would probably know this, right? I mean, I tell me if I'm wrong. If you're deathly allergic to something and I slip it into your plate, let's say I shove it into your taco or your burrito or into your salsa, and I cause you to fall over and die, well, what do you what would I be convicted of?
If you intentionally did it, you're looking at murder too, depending upon your state. If you didn't intentionally do it, you're looking at manslaughter.
Right.
Right.
And
I mean,
let's say you're just severely discomforted. That would be battery, like a mild. So what Chris is effectively being accused of is battering his children if he's doing it intentionally, right?
Mm-hmm.
Okay. And of course that's ridiculous. So now what you're saying, you seem to be saying, Chris, is that they're accusing you of neglectfully.
So the new claim.
I'm reading his order right now. I mean, I'm looking.
Go ahead, Sean.
As we speak, and so first of all, it's got hearsay within hearsay inside the order, but then it flat out says that Chris gave his son, who has a peanut allergy, peanut butter.
And it says in there without him knowing.
Without him knowing. And so I'm actually a person who's allergic. I did 4.5. I have really, really bad environmental allergies. I did 4.5 years of allergy shots, so I learned a lot about allergies and peanut allergies. People who have peanut allergies, it's typically pretty nasty. It's typically really bad, and you're looking at really, really adverse reactions very quickly in very small doses. So if your kid's really allergic to peanut butter, and they drank a shake with peanut butter in it, and you're most likely looking at the fact that they would be looking at a trip to the hospital.
That's true. Now, when you mentioned hearsay, and maybe we can get Connie's view on this, Sean. Is there hearsay from children in that order?
Oh, yeah. Well, yes. So I'm looking at the order right now. So this will be fun for the other lawyers, right?
Yeah.
When defendant returned to the room, the nurse practitioner told the defendant, so the defendant is Brittany, Chris's ex wife, told the defendant that while she was gone, the child had relayed to her that when he was at Chris's house, that Chris had put peanut butter in a workout shake without telling the child, and told him later there was peanut butter in the shake. So we've got wait. I
want to get this straight. Okay, so
we've got.
So who signed the affidavit? So who signed this affidavit?
Well, first of all, it's not even an affidavit. I mean,
Okay.
let me scroll down. Wait a second. Yep. No. It's signed by counsel. So great. So we don't even have, it's not even sworn.
Not even verified.
So
So you've got a mother, so you've got the counsel saying that the mother said that she was at the doctor with the child and she stepped out, and when she came back in, the doctor said that the child said, right? So we're up to four
Yeah.
times removed information, right?
Yeah.
I think there's a reliability issue there, a credibility issue.
Connie, how often do you run into improper use of child hearsay in CPS cases in Tennessee?
Well, with ex parte orders, there's some bad stuff. It's horrible. I mean, if I'm in a hearing, I mean, usually I can fight a lot of it, but it kind of depends on the judge. But in Tennessee, we have a rule 80325, which allows for the statements of children if it is a disclosure of abuse. Okay,
Right.
So that sounds like an okay thing to do, but you can challenge the credibility of that as still under Tennessee law. So whether or not there's you can challenge questions like whether or not there was any influence, or you can kind of put that in the court's mind if the child said something and it was in the presence only of one parent and nobody's ever heard it before and things like that. So but I mean, DCS is horrible. This whole four times removed hearsay. I mean, DCS, worse than that, they use anonymous referrals, and then a caseworker goes and puts it in an affidavit and signs under oath that she's got personal knowledge of what has occurred, and she hasn't done any investigation. And it's all an anonymous referral, and there's usually double or triple hearsay in there.
So
hang on a quick second, Ted. Chris, is it okay if I identify opposing counsel?
What do you guys suggest? You're the attorneys. I spoke with my mom. She feels that it's unnecessary. I don't. It's up to. What do you guys think?
So that's okay. I don't need to. We know that they like to watch this. So we'll just refer to them as opposing counsel. So opposing counsel, here's a book. You might remember this from law school.
Requirements on evidence.
It's called Evidence, right?
Yeah.
Evidence, right? And there's a whole section on hearsay. You might want to review it.
Well,
I want to ask, what state are you in, Chris?
I'm in North Carolina.
Okay, so and this is a domestic court, right?
Civil, domestic, yeah.
So, and Ted, you may want to make a comment about this too, but in Tennessee, restraining orders in domestic court fall under the Tennessee rules of Civil Procedure Rule 65, where you have to have a sworn affidavit of such facts that would create irreparable harm, which is why a restraining order or an ex parte order has to be entered without a hearing. So the fact that it's not verified is a huge issue. Are you looking, Sean, just at the order, or are you looking at the actual application for the order?
What I'm looking at is what Chris emailed to me, which was presuming that he emailed me everything that he got, which he's nodding his head. So I'm looking at the motion. And then a counsel emailed a draft order, which Chris said was later signed. There's there's a statement from Brittany as to theoretically the truth inside of the motion. But aside from that, there's no documentary evidence. There's no statement from the nurse practitioner. There's nothing.
Okay, but did Brittany sign it?
Documents. They reference documents inside the motion, and there's no copy of the documents.
Right. And did Brittany make a statement either under oath or a declaration under oath?
Technically, no.
Okay, in Illinois,
Technically, this does not mention the laws of perjury of the state of North Carolina.
there we go.
All she's saying in this is that the stuff that's inside this motion is true of her own knowledge, which,
yeah.
yeah.
So I want to go back quick before we continue on with Chris's story, Connie, because what you're talking about is so important. If I understand you correctly, what you were describing in Tennessee in the CPS cases that you have, that as long as it starts off with a child making a statement alleging some form of abuse, which could be my daddy's giving me peanut butter, that is, if it's passed on 10 different levels, that or degrees, that it would still get to the judge as long as it starts with
it's not supposed to. No, it should not. No, it would be it would have to be the person who heard it, because you would have to be able to cross-examine that person as to where they were, what the circumstances were, whether or not they'd made any comments to the child. So you have a right to cross-examine the person who actually heard the statement. So no, you can't do it 4 times removed. And there's really a question about that with even medical records, because even though we know that statements within medical records for the purposes of diagnosis and treatment can be admissible, right? If you get a certified copy of those medical records. However, if a child is there for a cold or a flu, and the child says, my mommy locked me in my room, that's not really a statement for the purposes of diagnosis and treatment. So you should not be able to get that in through the medical records alone. Now, I mean, we got a lot of crappy judges, and judges allow a lot of crap to come in or not come in or block evidence. And unfortunately, when you get to the Court of Appeals, it's an abuse of discretion standard, which could be a whole discussion between counsel educating the public about, but very, very difficult. I mean, you have to fight to get your evidence in proper format and get everything in that you need.
Now let's talk while we're on this subject, Connie. Let's go back to Chris, okay? And let's figure out now, Chris, you got an emergency protection order. She's making all kinds of hearsay statements about the children, about what the children have allegedly told so-and-so. Now, Chris, when are you going to be able to talk to the children and get your own hearsay testimony from the children?
I speak to my children all the time, but I'm aware of the law and understand that it's hearsay, and have not tried to admit hearsay. And when I did try to admit a recording or request during the last modification hearing that the judge sit in chambers with camera audio and video and speak to my children about these allegations, the judge, asked opposing counsel, or do you oppose this? And he's like, well, yeah, but we can't, that's something I have to handle later on. And that was sort of pushed off. So, I speak to my kids. They say very different things than what all of this says, including, during the hearing, it was all about my social media, and that my social media, my kids are seeing my social media, it's causing them emotional distress. And as we've talked about, why are children seeing adult things without adult supervision? I don't let my kids see things that they shouldn't see on the internet. They don't watch my podcast. When I asked my son knows I do a podcast, he asked me what it's about. I said it's about parents and kids working together. And I left it at that. Oh, he's like, okay. He's so proud of me. And he shows the teachers my music. I have a song called Me for Tennessee on YouTube, and he Googles my pictures for his classmates to show them his daddy. And that's really what this is about. And they twisted it, saying that my kids are definitely seeing it, and that's all hearsay. And on Sean's advice, I motioned to reconsider, which I have coming up, to have all those hearsay and lies that opposing counsel created the custody order, and the judge just pistol whipped,
Now, Chris, I think you might have committed a really, really, really serious mistake. And this is a cardinal sin in family court. When's your next court date?
So I guess this next court, I don't know the date.
Before this all happened, when was your next court date?
It's September 1st, and then it actually went to September 2nd, and then back to September 1st.
Okay, so September 1st was scheduled for how long?
I guess I just put for 1 hour because it's the motion to reconsider the order.
But your last court date was several weeks ago, and then they scheduled your next court date would be September 1st.
Correct.
And you filed your motion for reconsideration when?
I think within the 10 days. It was. I think it was right on the 10th day, if I'm correct, right, Sean? We did it on the Monday, which was the 10th day because it was the weekend before. And then I think it was right at day 10.
And then you're going to present it. You filed this several weeks ago, and you're going to present it about 2 months from when you first filed it.
Yeah, I guess it would be 2 months.
Okay, so you gave them 2 months to know that in fact there are multiple things in that order.
Sean's saying no, but I filed it no, I guess it's not 2 months, is it, Sean?
Ted, I think this is a simple motion for reconsideration,
right,
about his entered order.
Right, exactly. But I'm saying is that he gave them 2 months notice.
No,
the judge. Oh,
no. From what I understand, it's like a 9 or 10 day calendar.
Okay, to file a motion for reconsideration. Right.
Let me clarify. He had 10 days to file the motion for reconsideration because the North Carolina rule closely paralleled CR 59.
Okay.
And I believe that the motion on that was on a 9 or 10 day calendar in North Carolina. So he probably actually should already be looking at having a new order returned or either a response to his motion. Chris, did they ever file a response to your motion?
No, I haven't gotten a response.
Okay, so this is what happens. This is what happens a lot. Is that I see this a lot, and it's happened with me. Is that when you got the other side stone cold busted, okay, claiming things that are objectively false, easily provably false. What you'll do is you'll see them come in and preempt you, and pull the rug completely out from under you with EOPs. Okay, that's what I'm suggesting, and what you suggested might have occurred, is that this was a preemptive move by them, which is just another way, just another game, another trick, another part of the playbook of domestic relations courts. Possible, Chris, that happened.
Yeah, I'm trying to dig up what the motion calendar timeline is in North Carolina. I don't know.
Right. So you had to disclose this. You had to do this, and they know that the litigation arising from your first hearing isn't over yet. So
correct.
So now he properly served them.
Now, Connie would probably agree with this. And Connie, if you want to give me some of your knowledge on how.
For sure. I mean, and I've dealt with attorneys like that. Like every time you turn around, they're pulling something. I mean, just about the time you think you have, this is what they do to me. I mean, every time I am just kind of cruising along, they pull some whammy on me, personally. But yeah, this for sure. And, and it's psychological warfare. It's now, did they not put a date for you to have a hearing on this emergency order?
So it was for this emergency order. It had just been signed by the judge at 4:04. It was clocked in to the clerk's office.
Okay, but typically in Tennessee, when any emergency order is signed, they put a court date right on that emergency order.
It was left blank.
No, he's talking about the draft order.
The draft order. I have not received a copy of the signed order as of yet.
Oh, but how do you know it was signed?
Because the clerk emailed me and said, there was her attorney and me, and the clerk was saying, attorney, you can come pick up your signed order.
And they're not going to send you a copy first?
I guess he's going to mail it to me, and I'll probably get it on Friday, the day of court. That he likes to send me things on.
Okay, so you need to call the clerk's office and ask them to give you a copy of.
I emailed them and didn't get a response about that.
How far away are they from you?
15, 20 minutes.
Yeah, well, you should be down there Monday morning.
I will be.
Make sure you have a video or some kind of recording device. Does some courthouses don't let you carry phones in? Does this one have that kind of restriction?
So the clerk's office is separate from the civil building, which is also separate from the criminal building. So there's 3 buildings. The clerk of courts is the old courthouse in Graham, North Carolina. And that's where all the administrative clerk stuff gets done. It's separate from the criminal and civil court buildings.
Okay, but you need to go to the clerk.
Yes.
And you need to say, here's my case number, and there was an order entered Friday, and I need a copy of it.
Mm-hmm. Yeah.
And,
so
and
I
you
don't
need to
even know what
ask
the
them.
date is.
Okay, well, but there was a line for a date on the order that you received,
And
right?
it's supposed to be within a week. I think it's supposed to be,
Right.
The court date's supposed to be a week.
All right, so how are you going to prepare for this?
This was the first thing I thought of, guys.
Okay, all right,
Let's
hold
talk
on.
about it.
Okay, hold on. All right, so
I
what
don't want to talk too much about strategy on here, right, Connie?
Well, I want to know what you're going to do.
Well, I'm going to try and get an attorney.
All right, but I just want to talk about the practicalities of it. So what I've heard so far is that this order alleges that you gave your child peanut butter, but he didn't know it.
That I gave him peanut butter unknowingly. So how does the kid know?
That you gave him peanut butter or peanuts?
Sean, would you mind reading that part of the order? Or that motion? I think it's number 9.
Is he muted?
Yeah, he's muted. You're unmuted. Sean, you're muted. But you did a great mime job.
Sorry. What they're saying is that you, I'm gonna find it here, that you told your kid that they did not have a peanut allergy after they drank the shake. Oh, I found it. That Chris had put peanut butter in a workout shake without telling child, and told him later that there was peanut butter in the shake, and that this demonstrated that the child did not have a peanut allergy.
And no reaction whatsoever. No
Okay, and
reaction.
how old is this child?
He's 8.
Oh, okay. So he told. So allegedly, though, from what I heard Sean say earlier, is that your son said this to the person at the doctor's office.
The nurse practitioner.
Stop. I'm gonna read number 9, so we've all got it out here. Okay. On July 21st, 2021, mother had taken the child to their pediatrician's office due to both children having a significant cough issue. Mother had stepped out of the room to take child 1 to the restroom, and child 2 remained in the room with the nurse practitioner. When mother returned to the room, the nurse practitioner told mother that while she was gone, child 2 had relayed to her that when he was at Chris's house, that Chris had put peanut butter in a workout shake without telling child 2, and told him later that there was peanut butter in the shake, and that this demonstrated that he did not have a peanut allergy.
Okay.
Child 2 also mentioned that child 1 was given ice cream while in Chris's care. The nurse practitioner gave mother a prescription note which read that they have allergies.
Okay, now, Connie, is this sort of a familiar pattern that you see where step 1, how do we get to an EOP, especially in family law cases? Step number 1 is have the children go to an unsuspecting mandated reporter. Is it
Okay, but you know what? I'm just going to talk practicalities here. Here's what I would do, or if you were my client, here's what I'd tell my client to do. I'd say you go down to the clerk's office Monday morning, you get a copy of that order, you find out what the date is, you have a subpoena issued right then and there for that nurse practitioner and to the doctor's office for all medical records for the past, I don't know, 90 days, 60 days. And now we have some restrictions in Tennessee about who can serve a subpoena, but I would have that subpoena served by noon on Monday. And, they're going to bitch and moan and groan about it, but that because that's a source of your issue here. So that's what I would do. That's what I would tell my client to do. That's what I would, that's.
And I know that Mom's raising her hand.
Go ahead, Mom.
Okay, so when Chris spoke to the doctor today, she said if that had actually happened, the nurse practitioner would have put it in the notes, and she does not see it in the notes, nor does she see the supposed note that was handed to the mother.
Okay. I'm not sure we necessarily want to tell the other side.
Okay, but you know what? None of that's admissible. Okay, that's not evidence. That's not evidence. So let's talk evidence and let's talk about what you do. Okay, because I tell people this all the time. You can tell me a dozen different things. If it's not evidence, if I can't get it into the court, it's nothing. So that's what you need to do. You need to go get a subpoena for the nurse practitioner to come to court. And you know what? They're going to call you and they're going to say, oh, we can't be in court. And then you're going to, you can either contact the judge's office and ask if they can testify by telephone or video, or these days that, we have a lot of judges who are pretty flexible on that. And maybe you can just get the person set up by Zoom or telephone and ask those questions. And let's just get it out there, because if it didn't happen, then you're going to have it documented that she's going to look like a fool, and you need to have it on the record. I take recorders to court and record the proceedings. Court reporters are expensive, and I've had some judge lately just get cranky about it, but there is a statute in Tennessee that says that you can record proceedings, and it's a 1972 law. And then we also have. Well, you need to dig into it and look at it, because I have judges tell me I can't, and I have to pull the law out and dig the law out. And we had a case in Tennessee that says that if there's a law that attorneys can do it, so can pro se litigants. And if you don't have a law that you can record proceedings, you need to be finding a legislator so we can get that law in the books. But you need to be getting that nurse practitioner to court some way or another.
Chris, have you ever filed or issued a subpoena in your own case before?
Yeah, so the modification hearing, I issued many subpoenas and no one showed up. None of the medical experts showed up. They all quashed it.
Okay.
And said obviously it was a conflict due to privacy laws, medical privacy laws, and then none of them testified.
Did you?
Okay, well let me say something about that. There are certain protections from subpoena, attorneys, doctors, etc. So if you have a medical doctor that you need to come to court, you can't do it that way. You have to do a deposition of them. You have to get a video. You can do it by video. I like to do them by video, but you can do it by video. You can get a court reporter, but your doctor's testimony has to come in another way. You can't subpoena them to court. However, I do not believe that nurse practitioners are protected under the same thing. And if they are, then when you get to that motion hearing, you're going to have to research the law a little bit on that in North Carolina. And then if they are protected, you need to be filing a motion to be able to get an evidentiary deposition of that provider.
Okay. So while we're on Connie's specialty, okay, where I was sort of going before is there's sort of a 3-stop train route to an EOP. Number one, start with a mandated reporter, right, Connie? I mean, we're talking counselors, doctors, you name it. Is this how these things normally start? Is that they unilaterally select some doctor to go to? I'm sure she didn't consult with you, Chris, and she's taking the children to a particular doctor. Oh, and then one thing leads to another. And of course, then it turns out that it's her that actually made this comment to the doctor, and the children didn't say anything about it. But then she transfers it. They always transfer this to the children. Okay, I don't know if you see this, Connie, if you've caught people, like I have in my own case. I caught my ex making an allegation to a counselor. Then she goes into court and claims that my son made the allegation. And there you go. There's a straight lie. I mean, this must happen all the time with you, Connie, right?
Yeah, it does. And yeah. And so I do have a question, Chris. You said they opened a CPS investigation. Is it on the same allegation?
Yeah. So the CPS allegation is that I intentionally give them allergens, and that there was one time my dad almost gave my son peanut butter. This was like years ago, but he didn't drink it. There was no reaction, nothing. This was like a year and a half, 2 years ago.
Okay,
right?
so this is kind of interesting because when did you get notice of the CPS investigation?
I was called, I think it was Monday or Tuesday this week.
And when did the kids supposedly go to this nurse practitioner?
So they went to, if I have to look at my dates correct, give me 1 second. I'm gonna look at a calendar so I don't misspeak. But
July
the kids
21,
left.
Connie.
Yeah, the kids
July
left.
21, Connie.
The kids left on the 25th. They went to the doctor on the 26th.
Okay, they left you on the 25th?
Yes, that's a Sunday.
All right, hold on here. I got to get my calendar up.
Now, the 21st was the doctor visit prior that I didn't attend. This was before they visited with me, and they had croup. They were having other ailments. Connie, they get sick.
Okay, hold on a second. So today's the 6th of August. So you had the children the weekend of the 24th and 25th. Is that what you're saying?
23rd, 24th, 25th. I get them on Friday.
All right, and they'd been to the doctor on the 21st. And this visit at the doctor on the 21st is allegedly when this happened with the nurse practitioner?
The 21st is, yes, on July 21st.
Okay, so they're at the doctor on the 21st, and there's an alleged allegation. You get them the 24th and 25th, and
23rd.
then, I'm sorry, 23rd to the 25th.
Mm-hmm.
And then you get the CPS notice when?
Monday.
This past Monday, the 2nd?
I think I got it on the 26th.
Okay, so you got the CPS referral right
The
after
next
you
day.
took them back home.
Yeah, I was at work and CPS called me.
All right, hang on. And then she didn't get a restraining order until today, the 6th?
I guess the CPS thing didn't go as planned because the CPS checked all the boxes that were good, and that the kids were fine with me. They felt safe. The house looked good, and the investigation.
Well,
was
if I were your attorney, one thing I would point out for sure, when you get to court, is that this allegedly report to the nurse practitioner was on the 21st. There certainly was time to file a motion, set a date, have a hearing before the 6th of August.
Before they gave them to me, even for my visitation.
Well, but even forget that. I mean, obviously she let them come and visit with you. They weren't so sick. She let them come. But from the 21st, when she got this information, until today, the 6th of August.
The day I'm supposed to get the kids.
That is over 2 weeks.
Yep.
She could have called her attorney if this were real. And this is what my cross-examination of her would be. Why didn't you contact your attorney on the 22nd, file a motion so we could get it properly set, properly before the court? I could get proper notice. I could get witnesses before the court and have it heard before my parenting time was to commence on August the 6th. I think that's pretty important. And maybe this judge just didn't pay attention to the timeline because, from what you were saying, I was assuming this had happened 2 days ago.
Yeah, no, this was a story that was manifested, and I was hit last minute to keep me from the kids.
Absolutely.
So,
well, Connie, what they're claiming is that one of the kids got pneumonia because of this cough, and that they now need to the cough, which worsened because not being given medication, and now he has pneumonia in the lower lobe, but it's on a course of antibiotics. And so they're claiming that because he gives them, because they're alleging that he supposedly gives them allergens and doesn't administer medicines that they need, that the kids are in immediate risk of harm. That's the allegations.
So
we have a diagnosis of pneumonia now?
They're claiming they have a diagnosis of pneumonia, but there's no documentary evidence here. There's no chart notes. There's no statement from a nurse practitioner. There's nothing, there's no copy of a prescription. None of that. So
with one of the best CPS attorneys in the entire country, possibly ever, on this call, let's go back, because Chris, hindsight's 2020. Everything went well with CPS in your case. I would talk to you about this. I was nervous about this. You were sort of poised that I'm going to record them. I'm going to be very defensive about that. And then the other, you got the devil and the angel on each side of your head, your shoulders, and one's telling you something, the other is telling you the other. How did you handle CPS in this case? Did you record them, or were you nice? Obviously, you were nice and pleasant.
Yeah.
And maybe Connie could give her insights on how you handled it and how these types of situations should be handled.
Yeah, and I can share the video on the sidebar with Connie and just let her see it. But I'll tell you what happened in a nutshell. Not a peanut shell though, because I don't want anybody to get sick. Yeah. So sorry. It's the only way I can keep going is making jokes. They came in. I told her I was recording. She got a little squirrely, called her supervisor, said that if I'm recording, she has to record. I said, fair enough. Come on in my house, record anything you want. Please do record, because I'm all about transparency. So I recorded. It's probably a couple hours. So she came in, told me what the allegations were, obviously wouldn't tell me the party's name who filed it, because that's sort of protocol, but we know where they came from based on the allegations. And then, of course, as I spoke and I referenced my ex as the alligator, it was never contested. So we know where it came from, because the allegations could have only come from the alligator.
I'm sorry, I have
the alligator. Oh man. So yeah, very pleasant. She was very sweet. I'll give that to her if she ever sees that. She's been very sweet. I called her today to let her know, because she scheduled a visit yesterday to be with me and the kids at 6:30. And obviously that didn't happen as of 4 o'clock. So I called her and said, hey, this is what happened. She's very kind. So I want to preface that. She seemed if I'm giving my opinion, her voice was very sympathetic.
I want to stop just for a second, Chris, because there's something important I want to ask Connie. Okay, Connie, there's 50 states in the union, and this situation is going down in any particular state in the country. Name me one state in which you wouldn't be able to record CPS in this circumstance.
Well, they used to tell me I couldn't record. Even in family meetings, they'd go like, you can't record. And I'm like, yeah, I'm recording. I mean, the first time that I really started recording was probably 10 years ago. And they actually stopped the meeting because they're like, we got to call our supervisors. I'm like, fine, call your supervisors. So, Tennessee's a one-party state. I mean, there are some states that require the permission of both parties to record, and you can find those. Well, yeah, but you know what? I don't think that applies to the government.
Yes,
right, and I'm in a two-party state, Washington State. So if you make a statement that you are recording, and they say, well, I don't consent to recording, and then they keep talking, tough.
And I think there has to be an expectation of privacy. And so certainly if you're having a conversation with a government employee about an investigation, I cannot imagine how they would have an expectation of privacy. But I always let them know I'm recording. And, I still have issues with them not recording interviews of children, which I think they should, but they don't. And we had a legislator who tried to make that a law and they still won't do it. But definitely my clients, I'm like, record.
If your children are in your house and CPS is at your house, do you have every single right to record your children while they're in your house, irrespective of whether they're being interviewed by the government?
Well, I would say there are certain people who have turned a recorder on and left it in the house. Let me just say it that way.
All right. I have a strong opinion on this, Connie, because everyone who's watching, I'm sure that some of the Family Forward Project will see this. They follow these things.
Mhm.
CPS, DCFS is subject to the Fourth Amendment, just like police.
Yes.
Now, in the Seventh Circuit Court of Appeals, we have a lot of cases that have affirmed that clearly. But the other thing that we have up here in Illinois, Wisconsin, and Indiana is this case called ACLU versus Alvarez, which is a 2012 case, which brought by the ACLU, where they want to do a program to record police, and they essentially brought a declaratory judgment and said, you can't arrest us for eavesdropping for recording police in public spaces. Well, they brought that case. They won in the Seventh Circuit, and guess what? Everyone starts getting body cameras. Why? Why did the police start getting body cameras? Because they're afraid that they're going to get falsely accused, just like we are.
Right.
So
I have used that case. That is one of my favorite cases where I've gone through and about the First Amendment, because that case talks a lot about that First Amendment right, and people need to remember that you've got that right to record, to document, because that Alvarez case talks about documenting the activities of public employees. So
any public officials.
Any public official, exactly.
The only line that it got close to that they didn't quite get there were judges, meaning recording court. But but in our three states, and that's a highly persuasive case, any public official. So what was happening with Chris is the same thing that happened with cops. Okay, she finds out that Chris is recording her, and she turns around and records him. Okay, which is fine. I mean, could Chris conceivably refuse for them to record? Yeah, he probably could, and they would probably leave, and there wouldn't be any interview at all. They probably wouldn't proceed under that, possibly. But for everyone out there, I mean, your case, this involves your fundamental due process rights as a parent. That is up protecting yourself against false allegations, people, misrepresenting things, getting the actual best evidence recorded. There's not only your civil rights, there is your right to advocate for policy changes and use evidence of your recordings for policy changes, or for whatever reason. Petitioning the government, speaking about public affairs is the most protected First Amendment right there is. So what Chris did, I guess you took a little bit of my advice, Chris. I didn't, no one wants anyone to be confrontational if you don't have to be. But sometimes you have to come up with your guard up. And in this case, Chris, it worked well for you. I think you did the right thing.
Yeah, she was a little off-put and uncomfortable, I think, for a second. She spoke with her supervisor, told me when she came back she was going to record. I said, you're welcome to, absolutely. This is about transparency for me. So I want her to record as well. Let's all record, everybody.
Okay, and when did she actually, as we lay out the timeline here, when did you actually talk to her?
So she came, so I spoke with her, I'm sorry. So I think she came on, I got the call, I believe, either Monday or Tuesday. I think it was Monday. And then the meeting was set up the following morning at 8:30 a.m. on Tuesday.
Well, and I could take the position with, people call me now a lot on cases early, right? When they get that first knock on the door, that first phone call, because, they immediately go to Google and start typing in Child Protective Services or DCS. And, I now on Google, on YouTube have a little over 100 videos, and I put the CPS tag in every single one of them, and people will find me early, and I will get involved. And as soon as they have the card of the DCS worker, it really becomes kind of a circus. But I immediately telephoned the DCS worker. And then, of course, let me tell you something. Tennessee DCS, I just found this out recently. They do training videos with my picture in it. Okay. I just found this out. So I have done an open records request for all the training videos that they've done with my picture in it and about me. I'm still waiting for that response. So I'm sure they have out there a memo somewhere that all they have to do is type my name into their system, and they get like pop-ups, flashing red pop-ups, right? That say, don't talk to her, right? I'm sure they do, because as soon they will never call me back. And then they get some DCS attorney to start getting into this email obtuse conversation when we could have had the investigation done. So, but I say, look, we're here to help you. I know the policy. The policy says that you're supposed to work with us. If there are services needed, we'll be happy to talk to you about it, but you're supposed to have a meeting on that and not just go off the deep end here. So I've been present. I had one family, they called me in early, and it was about, and they had some teenage kids, and a teenager and a dad had, they'd gotten a little, not rough with each other, but they'd gotten in an argument with each other. And when the DCS worker came to the house, I was there. And when he asked to speak to the child, I asked the child if he wanted me to be present, and he said yes. And so the DCS worker stepped outside to call his supervisor and came back in and then said it was okay. And we finished it and concluded it, and everything was fine. So, but then recently I had one where there wasn't even an allegation against the parents. It was an allegation of somebody else on a child. And then, and I said I wanted to be present, and the judge said no. So, there's no, even though it was in compliance with everything in the law, because the law says that the child will be interviewed outside of the parents and the perpetrator. I says, I'm not a parent and I'm not a perpetrator. It also says that the child will be interviewed in a neutral setting, in a location other than where the abuse occurred. And I asked for the interview to occur at my office. I said, surely no abuse occurred at my office. And the judge would not allow that, but he should have. And we probably could have appealed and asked for reconsideration of that conclusion. However, it's not we don't feel like it's a very retaliatory allegation and harassment. So we feel like it'll be put to bed pretty quickly. But, I say, tell them, yeah, I want to help you get this resolved as soon as possible. But I want to make sure everything is well documented. I want you to be honest with me as to what information you have, what information you need. And in particular with your case, Chris, to say to them, okay, so I think I think you need to have the doctor involved in this. I think, we need to maybe set a phone call. I'd like to participate in that or be part of it if possible. But I think you're going to have to get some medical records and see, to really get this investigation completed and work it for them, because they're horrible investigators. They're not investigators at all. Right. They just want somebody to confess so they can, so they can substantiate their case and close it out. They don't want to investigate anything.
Well, I think CPS isn't directly investigating the pediatrician. This was what was put in the motion for emergency custody. I think it's separate. I don't think CPS is speaking to them at all at this point, because I asked and she said, no, we haven't been there. But what's going on?
But the allegation has to do with that.
Yes. So it basically, what I'm guessing, and you guys give me your analysis on this, is she tried CPS. It didn't work right away. So then we filed this motion.
Well, yeah, maybe. And also, the way they've written this is they've written it to make it appear like the mandatory reporter might have called CPS. I mean, it says, and I quote, based on continued reports of the children being given known allergies, a report was made to the Alamance County Department of Social Services.
Okay, yeah. Whoa. So how would the attorney know that? because the referrals are supposed to be confidential. So how does the mother's attorney know, and she's putting in a court document, who made the referral to CPS? I would be jumping all over that.
What they're doing is the way that it's written, right? And it's signed by the attorney, and it's signed by the ex. And after this discussion about everything that's happened inside the doctor's office, this sentence, based on continued reports of the children being given known allergens, a report was made to CPS. It's placed and phrased in such a way as to lead the judge to believe that the doctor's office made the report.
But it doesn't go that far. It doesn't go that far, right?
Right.
Yeah.
And how would they know?
The doctors that I spoke with, the doctors, they didn't even have
but you can't. How would they know who made the referral? Because the referent is supposed to be kept confidential.
Well, I'll tell. I just from my own experience, and when you've been through this, you're connecting the dots. The answer is that your ex asked the doctor to call CPS, or the doctor asked your ex if you maybe I should call CPS, and your ex said, oh yes, please. Yeah, I think
or your ex asked the doctor to call CPS, and CPS said, I don't think this is a mandatory reporting sort of situation. I'm not actually going to go call CPS. And that was full stop. That's it. That's the end of the sentence. That would be in line with the fact that the doctor's office has no idea about this. And then your ex turns around and calls CPS, and then her unethical attorney writes this motion in such a way as to lead the judge down a garden path to the idea that it was actually filed by the doctor when it actually wasn't. And that's
so Chris, let me ask you a question, because I mean, in 27 years, I've had hundreds and hundreds and hundreds of cases, and I know a lot of attorneys, and there are some attorneys I trust and some I don't trust. And I know that there are certain attorneys who are evil and sneaky and crooked, but there's a whole other class of attorneys that on their own, they're not really that evil and sneaky, but they just believe everything their client says. They just hook, line, and sinker. They just believe it. They run with it. They just follow it. They have no common sense. And so, is your ex calling her attorney and saying, oh, there's a CPS investigation now, and not being honest with her? Or do you really think the attorney is in on it?
I think it's together. I think this is a group. This is an attack by both of them. She's feeding him lies. He's giving her malicious intent. He learned a lot in our last hearing. He learned that his client is a liar. Mm-hmm. For sure, I caught her on the stand committing perjury.
Well, obviously he doesn't care. Obviously he doesn't care if that was only a month ago.
This is a personal attack by the attorney, I believe.
I believe that we have an obligation to keep these kinds of attorneys honest. Okay, Connie, I took a volunteer job as general counsel of the Family Civil Liberties Union, so I am supposed to be encouraging a certification, certified ethical family attorney program. Okay, because we all know, we've all been through this, that I used to work in Washington for 15 years, where you deal with all these industries, and these industries say, government, leave us alone. We can self-regulate ourselves. The utilities, the oil, the gas, the transportation networks. Oh, just let us regulate ourselves. So how are we doing as attorneys regulating people like this guy? What's his name, Chris?
The attorney's name?
Yeah, what's his name?
We were gonna leave that out, weren't we? Okay.
Well,
for now,
it's not going to help me. Okay, let's say I want to give this guy a call and say, hey, please, can you stop giving our profession a bad name? Okay, or you send him a nice letter. Hey, can you please, just
I'm happy to share with you his name if you want to contact him afterwards, but I'll leave it out for now.
Okay. Well, that's a problem that we have, is that we're not supposed to talk about, we're not supposed to talk about bad policies, bad actors, sometimes bad people. We're just supposed to look the other way. And when colossal disasters occur, comedy, attorney, we're doing a terrible job regulating ourselves.
Well, but the other side of that, and I know this is a little bit of a bunny trail, but, the other side of that is then, they come after me, and they come after me because I'm vocal. And I went with 8 different sets of families down to the county commission because all these people had come to me and complained about our juvenile court judge. And so they want to know, where do we go? And I'm like, she's a county employee. Let's go down to the county commission. And so I told them, you need to have a 3-minute story. Let's take a picture. And we all picked a date and we all went down there. And that judge filed a bar complaint against me. And now they want to take my license away because these 8 families spoke out in a public forum about a public employee who's on the public payroll and the taxpayers pay for because of her attitude. And it's important to know that not one of those people that appeared were represented by me in front of her. So it's not like I was going to try to say that in this particular case, she treated me bad representing these people. They all had their separate cases, but they came to me after the fact and were just flabbergasted with what had happened. But now I'm the bad guy. I confronted another judge on the way he had removed children from parents, but the parents didn't even have custody. The grandparents had custody, and he never even served them. And, and he gets all over me about it. It's like, you know what? I'm just going to call it like I see it, and I'm sorry. So now he's filed a complaint against me, and he thinks I should have my license taken away. It's all like it's 6 different judges. And let me take it one other step further. I said, okay, well, if 6 judges are going to file complaints against me, I'm going to do video depositions on them, and I'm going to ask them questions. I'm going to put it on YouTube. Now they're trying to quash my depositions.
Yeah,
welcome to the club. Welcome to the club, Connie. I have a bar complaint against me as well, based upon forged court orders by unethical opposing counsel. She literally forges court orders, gets our baby judge to sign the things, then she covers up her fraud with subsequent orders saying, the court previously found this, the court previously found this. No, the court didn't previously find that. That's because you forged the profanity order.
Sean,
right?
real quick,
and then she filed a bar complaint against me, and that goes forward. I bet you Ted's got one of those stories.
Oh, but I wanted to defer to Connie just quickly, because I know you want to weigh in, but I have a question for Connie, because Connie's been doing this for 27 years. Okay. She's doing legal cases, and she's trying to educate, and she's trying to do public policy. Connie, of all these bar complaints where people take it personally, that you claim that you're personally attacking them, how much of the time are you simply trying to educate these people to stop making the same mistakes over and over and over and over?
Well, and they are super offended by social media. I called out a court, and I referred to it as donkey justice on a Facebook Live. And so they filed a complaint against me for that. And I said, look, the United States Supreme Court is the one who coined the phrase kangaroo court, and it was about juvenile court. So you're talking to me just because I say it on social media and the Supreme Court put it in an opinion. I mean, there are problems. I will say I started being really kind of politically active in about 2007, 2008, because of the way judges were handling things. It just became so outrageous. It was driving me crazy. And we did get some legislators involved, and we did get we ultimately got the recusal, the manner of recusal redone. But, it's been it's nonstop, and they get black robe fever, and they think they can do what they want. And, and they retaliate against people who call them out, and they hate social media. And I'm like, I'm just going to call it as I see it. So people need to be educated, and people need to feel more empowered, because they get into these situations and they feel hopeless and helpless. And, a judge can do everything to you. A judge can take your land away from you. A judge can take your kids away from you. A judge can put you in jail. They can take your money. They can do everything to you. There is no limit as to what can happen. So people have all this anxiety, this litigation anxiety for good cause. and it's ridiculous. So, people should look at a judge as a person who is there as an impartial tribunal to determine a dispute of facts and apply the law. I mean, that's for those of us who went to law school and took a bar exam, I mean, that's what your bar exam is all about, is understanding what the issue is, what the rule of law is, what the supporting facts are, and what your conclusion should be. And that's what a judge should be doing every day, and not all these other shenanigans that are going on.
And it's a normal interpersonal communications in the court process, that the normal relationships between people, like they like to go on golf outings and just sort of be normal with one another, because you can't be normal in court. Like, the weirdest thing about being before a judge is you can't compliment them. That's seen as inappropriate. But then, you can criticize them, but you can only criticize them so much. I have a case, my own case, how I got involved in this, is that I had a judge, a domestic relations judge, that didn't read pleadings. Nothing. He had no idea what was going on before him, what was up at any time. It's if he hears something, we heard he had Parkinson's, and so he violates rights of parents by the hundreds. I mean, he was horrendous, and he wasn't entering orders. He was just cutting hearings off, forgetting what he did, reversing himself, acting bizarrely. And so obviously I got into it with him because he was impacting my rights to my children. I appealed him to the Illinois Appellate Court and won, and got my custody judgment vacated, and he ignored it. He never even read the opinion, never even read it. Okay, so I'm getting into with this guy because this guy is violating a state appellate court remand order. And so finally, what he starts doing is he starts sending ARDC complaints against me. So because he couldn't believe that actually two other parents that have him came to me and asked me to represent them. So he accused me of soliciting them. Like, I didn't know these people. So I got an ARDC complaint for that. And then I was getting into verbal joust. It sort of did. I mean, truthfully, did get to the point where I'm really despising this guy. And I'm not talking as an attorney. I'm talking as a father. Well, so anyway, these leftover, things where I, allegedly crossed the line. I think I called him a clown. Not good, but I did. Okay. And as a father who has had my civil rights violated for 2.5 years, I had a 7th Circuit case ongoing involving safety plans. Okay. I mean, he violated a consent decree that Diane Redleaf did. And I'm just trying to get a hearing on that. And this guy's retaliating. He has no idea. So anyway, he goes out with a brain tumor just a few weeks ago, back in June. And so everyone knows that this guy was impaired for a long time. So the ARDC filed a complaint against me for the intemperate language that I used. And I turned around today, like you did, and I subpoenaed all his MRIs, all his CAT scans, and all his PET scans for the brain tumor. I mean, the entire town knows that he's out permanently with a brain tumor. And I want to defend myself with his own brain imaging, because they're not disclosing that. So okay, ARDC, you're claiming me that you're just saying I got into an argument with a judge. I'm saying I got into a judge with a latent frontal lobe brain tumor.
Oh my gosh. We had a judge in Knoxville who was using cocaine on the bench. It was so bad that one of his criminal defendants, a female, was in the hospital at one point, and he actually went to the hospital to get some cocaine from her. And I mean, he was for years, and everybody talked about it. It took forever. I mean, there were so many people damaged by what he did. I mean, it's horrible. So
it's worse. I mean, we share the same political views, Connie. I mean, I don't know what has the ability to do more damage: a president who has certain limitations, and a domestic relations or juvenile court judge that is completely off their rockers.
Absolutely.
I mean, I don't know what's more dangerous, because someone will stop President Biden from pressing the button. We know that. I'm not concerned about that. But with these people that have no oversight, and the attorneys are looking the other way and even profiting off it because they know it's just a circus.
Yeah, there's definite profit off of it. And, I live in a pretty wealthy county. I mean, Williamson County, Tennessee is, I think at one time I heard it was like the 11th wealthiest county in the country. So we have a lot of high-end divorces. And, you know, and I was in Davidson County, which is Nashville, Metro Nashville before, which is a much more diverse community. And I moved down here, and it wasn't long before I realized the game of domestic attorneys. And, you know, I'll just call it what it is. I mean, a domestic attorney knows everything about you. They know your bank records. They know your credit cards. They know your spending habits. They know how much money you make. They know how much money you're saving. They know the value of the house. They know how much money you owe on the house. They know exactly how much money they want to get out of you by the time the divorce is over. And I mean, on many occasions, and there was one particular attorney that had the reputation that he was going to make $100,000 off of a divorce, and then he was going to settle it. And, you know, that's, it was not unusual. And it's very frustrating because it just creates a lot of chaos, you know, in the process that's unnecessary. I had this one judge order me. I'm just going to tell the story since we've lost our guest. We're supposed to be interviewing.
Yeah, I don't know. I just texted him. I'm like, where did he go?
So let me tell you this story. So I had a judge story. So I represented a man who had been fairly successful. He had a nice home. He was a gun collector. He was married. He had like 5 kids, and you know, he had a rough wife. She had some mental health issues, but anyway, they're going through a divorce, and she moves out, and he's in the house with the kids. Oh no, she hadn't moved out yet. I'm sorry. So she gets this attorney who files this motion that it's dangerous in the house because he has all these guns. And so they get the judge and listen to this. They get this judge to enter this order that I am supposed to go to his house, which is way out in the country in Williamson County, that I am to inventory his guns and his ammunition, that I am to secure it in his safe, that I am to change the combination to his safe, that I will then take this new combination and file it secretly with the clerk of the court, right? And I'm like going, okay, wait a minute. What if this man is so dangerous, why is a judge ordering me, his attorney, a woman, to go out, you know, 20 miles away in the country and do this inventory of the weaponry? I had to file an emergency Rule 10 application with the Court of Appeals and to ask that be set aside. And you know what? It was such a stupid order. I couldn't even think of good case law to argue, right? What do you argue, right? So, I mean, I was like, what can I argue? You know, you're like racking your brain. And so, you know, I put in there like the judge was making me a witness to the case, that it was sua sponte, it hadn't been asked for, that, you know, it was relief that he had just generated on his own without any hearing or request. So, you know, it's just crazy. It's just crazy that sometimes they just do things that they don't even allow you to have an argument about or to you know, have some type of due process. It's just that simple.
Right. And all we're trying to do, I mean, when we get into arguments with these people, is just to educate them with the time that we have. And I mean, especially you, Connie, I mean, you have such a big focus on so many people. You're trying to help the broader population. Ideally, the most honest people are people that work themselves out of jobs. Your goal would be to fix everything and then live a happy life, right? I mean, that's what an honest person does.
Yeah. Well, you know, I will say that, you know, part of our motto in our office is bad behavior is good business. So, because, you know, there's always going to be bad behavior, you know, there is enough of it, but, you know, I'm pretty strong. I'm pretty forceful with my clients. And, you know, I just did earlier today with Chris. I mean, if he called me, I'd say, okay, well, this is what you're going to do. And if you don't do it, don't even call me back, because I'm telling you what you're going to do. So, you know, I just don't mess around with it anymore, because I have too many things that I have to do. I can't babysit them, but I'll tell you exactly what you need to go do. And I'll be prepared. And if you do those things, when we walk into court on whatever day it is, I'll be ready to go. And, I think I'm getting too old to litigate just because I don't like to get up early in the morning anymore. But, I'm a great litigator. I just am. And I have an incredible memory, and I can recite. I can do an opening and closing statement without a piece of paper in my hand. And I've had judges comment to me on that, and just, say like, Miss Regula, you did that whole closing argument without even looking at a piece of paper. I'm like, I don't have to, because I know it. But and I always have my exhibits ready to go. I have them in folders. I have them copied. I have them, everything ready. So. But, I expect people to listen to me and, help me get the facts straight, and then help me get their case prepared.
Well, and they're so afraid of you that they actually make their employees do training. So you are literally causing these people to get trained because they're so afraid of you.
Absolutely. And when I get that training, I'm going to put it on YouTube too.
Oh, that's wonderful. So, Chris.
That brings up an interesting point because I think that a real problem that I'm seeing in my case, and that I've seen from what my research has been, is that judges don't keep up on where's the science, what's actually happening. They lock into a particular dogmatic vision that's usually related to their political point of view, and they don't see anything else other than that. So for instance, we're all inside of the sort of the shared parenting umbrella, and the one of the driving issues of that is parental alienation, which is an issue going on in Chris's case, right? An issue in my case, right? An issue in Ted's case, right? And we've got this entire side of the equation that is pushing back on it, pushing this myth that parental alienation is a myth, that it doesn't exist, that it's, junk science, all of that. And yet, you turn to this month's issue of the ABA's, magazine for litigation, right? And contained in there, right, is an article, drafted by arguably one of the best parental alienation lawyers in the country currently. Who's right that? Where he's interviewing a lead researcher on parental alienation, and they're talking to judges about it. But yeah, when you're inside of these courtrooms, when you're trying to talk to your judges, you're like, hello, here's a blinking neon sign that says parental alienation is happening right here, right now, for this child, for this family. Pay attention to it. And what do? Oh, well, I'm the judge here, so my middle name must be Deity. And, if I don't think parental alienation is an issue, then it doesn't really matter.
I want to weigh in here because everyone knows Cash. Connie knows Cash. Cash was our gubernatorial candidate for the Libertarian Party in 2018. We got so pissed off, he ran for governor and raised this issue. So a lot of people know who Cash is. And we finally had Cash's hearing. So they took away his rights to his children because he moved to Arkansas, and then gave him a hearing 2.5 years later. Seriously, is what we just went through with Cash. And so his case started off, and Sean and Connie and Chris know the difference between gatekeeping and alienation. I hate to call a case an alienation case because you're basically shooting yourself in the foot. You would rather have a restrictive gatekeeper, someone who's trying to keep the kids away, but the kids are still attached to the targeted parent. So what they allowed to happen in Cash's case is that with his daughter, but not necessarily with his son, the daughter was sort of drifting away. The son was fine, but then they separated Cash from both of them with no contact, and then allowed these false beliefs to come in, where the son is claiming that dad made him do 250 to 500 push-ups at a time. Okay. And his daughter was under the mistaken belief for 3.5 years that her father allegedly called her a name, when in fact our family wizard, the text messages indicate at that very date, the mother claimed that he called her a name, not the daughter. So then it gets projected onto there's all these things. I tried to get into that case, and Cash was on this. The issues of signs of enmeshment, which is usually a sign of gatekeeping. where the mother was co-sleeping with the daughter at 8. I mean, Connie, I'm sure that you've had cases where CPS actually comes in those cases and says that's unhealthy. So we try to get that in, and the judge is just sort of snoozing it around. Okay, there are multiple reasons. Is number one, making that child connected, afraid to sleep somewhere else. Okay, so what was happening is the daughter was coming in to Cash's room while him and his significant other were sleeping, and tried to sleep with them because they had an attachment disorder. So it ties him to the mother's house, but it's also unhealthy. And I asked the question to his ex-wife, Julia, what does the American Psychological Association recommend that parents and children stop co-sleeping together? And the answer is 0. The answer is never sleep with them. Okay, but she's doing that at age 8. That the court in Cash's case and all these others have no clue what's going on. They'd have the slightest clue about what we could find on the internet in 5 minutes. Stephen Miller, other experts, the people that you've had on, Chris, Jennifer Harmon, they know the signs, and these courts don't know a thing.
It's too hard. It's just too hard, Ted. You're talking about something very difficult. And I look at the medical kidnapping too, because, that's a big thing now with CPS. And, the big thing with fractured ribs, the shaken baby thing is a whole nother conversation. But we have a rash right now of babies who are born with metabolic bone disease, and their ribs are actually so fragile that they incidentally fracture upon handling. If you pick a baby up, because you always hold the baby by his ribs. So these babies will have 22, 25, 29 fractures all over their rib cage. I mean, and we're talking about a rib. I don't know if I could hold it up here. I don't know which way to hold it. Okay, so we're talking about a rib that's like as big as between my fingernails, right? I mean, they're like 3 centimeters, right? And but when you take an X-ray and you blow it up, I mean, and of course it makes the rib, look like it's like that wide, and somehow a parent had to crush it. And these child abuse pediatricians come in and talk about what the only way that could have happened is if they crushed the baby with their hands, right? And I'm like, well, then why are there fractures like all over in different places? Why is there not a single rib that's displaced? Every single rib is just like fractured. Why is there no internal injuries? Why is there no bruising? Why is the child never in discomfort? If this is abusive handling. So, I mean, even I have one doctor I've worked with, and he says, circumcision, strapping a baby boy to a board and, doing a circumcision can fracture ribs, right? So, so now we have DCS coming in, they have child abuse pediatricians, and these child abuse pediatricians just sit up on the stand and they go, well, the only way that could have happened is if they crushed that baby with their bare hands, right? Wow. And I go like, okay, so let's just talk about background and research. Is there any research that supports your conclusion? Is there any actual research? Because, in medical literature, you have actual research. You have what is called opinion papers. You have case studies. You kind of have summary papers. But research is where you actually do research, right? I mean, it's not just an opinion. And, the only thing that they can come close to is 20 years ago, they used to take fetal pigs or fetal cats or fetal rabbits and try to mimic this type of abuse and get the same injury, and they couldn't do it. So, there is no research on it. It's just an opinion. And, and yet, it took me, I won a case on one of those cases. Now I get a little bit better in negotiate, get DCS to negotiate a little bit better. But I won a case, but I had to put on medical testimony all day from 2 experts. I had one of them that was a video deposition of 3.5 hours. And then I had to put the other one on live, and it was another 3.5 hours. So it took 6-7 hours of medical testimony for me to educate a judge on this 40-minute deposition of a child abuse pediatrician who said, well, the only way it could have happened is if they crushed that baby with their hands. So taking the time to educate a judge is so, so difficult. And we really don't have enough good mental health professionals to really isolate and break this down. The biggest problem that I see with parental alienation, I mean, and I've been in this when people didn't even know what that word meant, right? And so, but we still knew something was going on. And then we had crazy Dr. Burnett here at Vanderbilt, who I think, you know, I don't want to get into a discussion about him, but, you know, he sort of started that. He's the one who tried to get it in DSM-5, et cetera. He kind of got a few psychologists. I used to call them the Forensic Boys Club of court psychology, where, you know, they had the same 5 people show up all the time. It's like the script. They all said the same thing when, you know, depending on who was paying them. But to really get down and educate on that, because it's not as simple as one label, one cure, right? I mean, I have had a psychologist come in and just really talk down to the details about observing a parent interacting with one parent interacting with a child versus another parent's interaction with a child. So, but you know, you can spend $20,000 just on the experts doing that. It's very difficult. There's not really a good way to do it, but it's just the judges just aren't educated in that, and they're not inclined to get educated in it.
Well, we all sort of grew up, Chris, I don't know, you know, you're a little younger than me, but we were growing up as teenagers with the gateway theory that if with drug use, that if you start with marijuana, then it'll lead to one thing, then you're doing cocaine and heroin. Okay, gatekeeping is the pathway, is the first step into alienation. And so right now, Chris, your kids are wondering why they can't see their dad right now. And do you think they have any idea why they're not spending time with you tonight?
I think my oldest knows what's going on. We've talked about certain things, and I left it sort of pretty summarized, basically, like, because he has questions and it's hard. He's 8, he's almost 9. So I leave it as mommy and daddy are having trouble working together right now, so we're having to have a judge help us. But it's not about you. Just mommy and daddy are struggling a little bit. We disagree on some things, and we both love you, you know, and you know, I could definitely say, you know, I don't, you know, if you actually loved your kid, then you wouldn't be doing this to me or them. But I don't do that because it's not necessary at the moment. When they get older, they can form their own opinions. But I definitely soften the blow by saying, you know, I don't know what she said to him. I'm going to assume, because apparently they have in her care, not from allergens, because there's no proof that allergens cause croup into pneumonia and a respiratory infection, right? Because that's what they have now. When I got them, they had croup, and then, you know, then I give them back. I get CPS calling me. She, you know, my ex messages me and said, oh, now they have this because you went swimming, and you caused a respiratory infection and you know, a pneumonia, possible pneumonia, bronchitis, possible pneumonia. But you've had them, they've been on steroids and treatments, right? Correctly. My kids have medical records thicker than the 4 of us combined. And I had a chronic kidney disease growing up half my life. They've seen the doctor virtually almost, I would say, at least 1 to 2 times a week their entire life for everything. They've had procedures.
And how often are they sick when they're about to see you?
How long? What? I'm sorry.
How often are they sick when they're about to see you?
I'd say I would probably, to be fair, I would say half the time, and I might be undershooting it. 50 to 60% of the time. I would even shoot at 70% if I was being aggressive. I would say half the time, to be fair.
So what you're doing right now is you're basically treading a fine line, because you're telling the court everything that they want to hear. Oh, mommy and daddy are just working things out. Nothing's the problem. Okay. Sean, I mean, I don't know if you have a view on this. When is the, what extent do we cater to these courts that are screwing up our lives, making armchair decisions without really any thought. How much rope do we give them until we come in and say, you know what, I'm making the decisions about what is in my children's best interest, what is in their mental health, and that it's better for my children to know that their mother is keeping them away from their father than to allow the children to believe that their father doesn't care?
Well, that's a really interesting question because, that's part of what we're doing by doing this. But that's the other thing that's happening, by putting ourselves out there into that social media environment to get that message out, because we know that the internet is so broad that, there's no way that the child won't get that. I mean, in my case, I keep writing to Unethical Opposing Counsel, and I keep saying to her a variant of the same message, which is, turn to your client and educate your client that your client is destroying her adult relationship with our son by what she's doing today, because all of the research shows that eventually the children get to a point where they figure it out, and some don't come back. Some of the alienated kids don't come back, but many that come to the realization that my mom did restrictive gatekeeping. My mom used me as a pawn in order to hurt my dad, right? In addition to whatever it is that they're living through inside of, the alienator's home, when they come to that realization, they often cast their other parent aside, and they, flip, and they estrange themselves and estrange themselves from their now that they're an adult, from their alienated parent. And so the alienators don't realize that the damage they're doing to their own relationship with their child in the future by basically targeting their ex for whatever reason they've got.
So this is my view, Chris. I'm just going to stop. I'm not going to ask a question. I'm just going to state my point of view. Is that the counselors and all these people that want you to not tell your children anything and let your children be out in the wilderness, why they're hardly seeing one parent but not the other. The next time you see your kids, you have to sit down with them. I would. And these people can all go to hell and say, you know what, kids, I'm sorry. This is a tough thing. You'll learn this when you'll get older, but your mother didn't tell the judge the truth. And sometimes adults don't tell the truth. That your dad wants to be with you more than anything than you can fathom. Mm-hmm. Your dad is trying harder than you will understand. And you know what? They're really afraid. It's just all about control. They're afraid that you'll align the kids against them when they're working to align the kids against you. Mm-hmm. So aren't they already playing that game, and aren't you just simply engaging and setting the kids right? My son knows that my son figured it out himself. It was in the counseling session that I recorded that now I'm subject to ARDC charges for recording my own son in a counseling session. He said this. He figured it out at the end. I didn't have to tell him. And I don't regret it one bit, because he's a smart boy. But
we're infantilizing our children, and that's part of the broken education process. Is we treat them like dependent children, and we don't. I've seen kids that are extremely resilient and intelligent, that if you treat them like, I don't want to say like adults, because there are certain things you teach in stages, but you don't alleviate the truth by you don't just not tell it. You can soften it, and you can explain and give heart to hearts. You don't give details. And that's what I've tried to do. Unfortunately, my kids have told me things that are straight lies. And I have had to say, and I have no trouble saying this, baby, I don't know why mommy told you that, but that isn't true. And I'm sorry she told you that. And I don't make it any more bitter or angry or name call. And he's confused when I say that, but he's not distraught. So he's piecing things together, because that's my job. It's not. Go ahead.
Have your kids ever caught your ex-wife lying? Have they ever said, "Mommy lied about this," or "Mommy wasn't telling the truth," without you planting any ideas?
My son has questioned. He has told me that mommy said things that he put two and two together that things weren't true. Yes.
A couple of things. I just want to chime in a little bit. Ted said something about making a statement to the children that mommy lied to the judge. I would not do that. But on the other hand, Chris, what you have just said, if the kids say something to you that is false, that mommy said this, or mommy said you do this, or something that you have personal knowledge of, so it's about you, I would certainly agree that you should correct it. And I agree. I think you're right on to say, I don't know why she said that. I'm sorry. That's misinformation. You might as well teach him the 2021 words of the day, misinformation.
Yeah.
But I would say that that's not true, and I'm sorry that she's told you that. But I would not bring her in actively, even though she's not technically active, but I wouldn't actively make her a part of that conversation. In other words, I wouldn't throw it back for the kids to say, next time ask your mommy why she would say that. I wouldn't.
Yeah, that back and forth is terrible.
Yeah, I wouldn't engage them in trying to sort it out. I would, say, I'm sorry that happened, but people.
Yeah, I don't go, well, hey, why don't you go ask mommy this and tell her about this? So I don't feed it. I apologize to my son for the thing that mommy and daddy are doing, even though I'm not really doing anything, but I will not let my son believe something that's not true. I don't even a lot of times I don't even tell them the other side. I just say, baby, I'm sorry that she told you that. That's untrue. And I don't feed it. But I
think you should also encourage the discussion.
Yeah.
So, the one thing, if these kids that are going through this horrible turmoil, if we can turn this into them for a key learning principle, and if we can help them use this to understand certain things about communication. So, if you can encourage so you've got what, 9-year-old, right?
8 and 4. Yeah.
8-year-old. Okay. Well, 8 is getting there, so that you can say, if there's ever anything in your mind that feels confusing or makes you feel conflicted, like makes you feel uncomfortable, it's better for you just to ask me that question. And, and then, I think at some point you can probably also, say something about, do you ever ask mommy about this or that? But I wouldn't go much further with it.
Yeah.
So I would certainly encourage that conversation. There is another dad through our social media activity I've been in contact with for several years, and I've watched kind of his development with his son. And about 3 or 4 years ago, there was a situation with the vacation that he had, and he was extremely disappointed on how that had turned out. And I know I had some conversations with him after that about, okay, here's what you got to do. You cannot let that bad situation and your child's apparent rejection of you control going forward, right? So anytime you feel your child is rejecting you, and whether it's acting sick or wanting to call mommy, and you have to do it. You have to stay on your toes, and you have to take the temperature of it all the time, but encourage that conversation. And once a child gets around 9 or 10 years old, you can add to that conversation and say, you know what, life is like that. There's going to be people in your life that aren't honest with you, or that you question whether or not they're honest, or they treat you like you're not honest. And us being able to engage in this conversation and have this and talk about it and try to sort it out is something that we want to do. And what you're actually doing is you're training them conflict management.
Well, the conversation, Chris, will probably come up along the lines of, Dad, why didn't we see you so long? So it's a softball. I'm not saying you need to go and say, because your mother lied to that. You don't necessarily, but Chris, do you feel like you're in a state of war right now?
Constant for 2.5 years. Yeah.
And do you think that the state has effectively allied against you in an ongoing campaign against you?
I can prove it.
Okay. So that's the sort of concern.
But they won't admit it.
The concern that anyone would have, because the state, I mean, this is like, I sort of think of this in family court and these kinds of things as being in a poker game. You know, when let's say the four of us in a poker game, and it's me versus Sean, Chris, and Connie. Okay, it's all you know. Usually it's a free for all. Okay, but if you three are all trying to knock me out, there's all kinds of little things you can do. Like if Connie's low on chips, then Sean can lose a hand to her. It's a total different game when people are supporting you and trying to raise you up. But when everyone's trying to eliminate you and ganging up on you, you're toast.
Mm-hmm.
Just you know, comparing that to poker.
Yeah.
So I guess what I was raising is that you're fighting the gatekeeping phase. You're worried about your children having attachment pathology to you, and then saying, "Daddy's always leaving. Daddy's not reliable. Daddy's not going to stay."
Which is what's causing the anxiety that they're seeing therapists for, not watching me on YouTube.
Right.
That's just hearsay that they're saying that.
John?
I'd like to say something that's kind of that's a pivot a little bit. And I'm going to speak both from my own personal experience and from what I've noticed what's going on with Chris, and I want Connie and Ted to weigh in on this. So, you know, my ex-wife was a wonderful person that I spent an enormous amount of time with and had a beautiful relationship with her. I would suspect, because Chris seems like a great guy, except his taste in music is, you know, but I would suspect that, you know, the women that he chooses to associate with are also, you know, interesting, wonderful, vibrant people. And when the adversarial attorneys get involved, that what they do is they manipulate the belief structure of their clients. Now, those of us who went to law school, we all learned that client control, client management is permissible and ethical, but client manipulation is not. And it's a real fine line between what is client control and making sure that the client is behaving responsibly and ethically, and that we're complying with our duties, not as advocates, but as counselors, to give them best advice based upon everything that's going on, both the status of the facts of their case, what the law is, what we know is going on inside of their own family, what's best for them. Our role as counselor at law, not attorney at law. And instead, what happens is these unethical attorneys, they get involved. And they just get advocacy, zealous advocacy, and they manipulate the belief structure of their own clients into believing these things that they show up in these motions. When you read this motion that we're looking at right now and what's going on in Chris, it's entirely possible that his ex-wife, you know, has, who knows, you know, undiagnosed mental health issues, maybe, or maybe not. Maybe she's just a normal person like you or me or anyone else. But she's got an attorney who's there who's saying, you know what, this looks like abuse. You know what, this looks like this is dangerous. You know what, if you send the kid over to Chris's house, you know, and he eats a peanut butter and jelly sandwich, you know, it's bye-bye, you know, it's lights out. Instead of helping the client understand what would be best for them and their family and their children long term, instead they're pouring oil and gasoline and napalm onto the fire to make it worse. Why? So they can make a lot of money. What this attorney should have done in this situation is that he should have probably picked up the phone and he should have called Chris, since Chris is pro se, and he should have said, look, I'm looking at this situation here, you know, and there's these allegations that maybe, you know, you gave the kid peanut butter. Did that happen?
Mm-hmm.
You know? Right.
But, Connie, how many genuine I'm sorry, I didn't mean that to stop. Go ahead.
Conflict de-escalating tactics and techniques rather than conflict de-escalating tactics and techniques. So you know what? Since I know you like to watch this, counsel. That's what you should have done. You should have picked up the phone. That's in compliance with your responsibilities to your own client under RPC 1.5 to make sure that you're not charging her too much money. Under RPC 4.1 to make sure that you're being fair to opposing parties. You should have tried to have this problem solved in a non-litigated, in a non-adversarial situation. All you needed to do was to pick up the phone, call Chris and find out, are you feeding the kids peanut butter? He would have said, no, of course not. And you wouldn't have needed to do this.
Connie, of all people, I mean, again, you're here. I have to ask. Could you tell me what your view of a true emergency looks like? What are some of the cases that you had that were a true emergency? Life and death.
Well, I will tell you that I have been involved in a few cases in which there's sexual assault. I have been involved in a few of those where we have some pretty credible evidence. We have some pretty credible disclosures. That is an emergency. So right. I do have to admit to that. But other than that, and
career, what, a handful?
Oh, not yeah. I mean, at most in 27 years. Yeah. It's interesting about the allergy thing because I had a case. I had the faux allergy case, I'm going to call it, very similar situation where the mother actually hired a private investigator. The child was allegedly allergic to nuts. The mother hired a private investigator. The father took the child to a coffee shop in the morning and ordered oatmeal. And at Starbucks, when you order oatmeal, they give you a little package, and that package has like nuts and cranberries and stuff in it. And so he allegedly tore the package open and poured it in the oatmeal and then fed it to the child. The private investigator went in the trash can of Starbucks and took out the package of oatmeal and the package of nuts and, preserved it. And I mean, crazy stuff. But, that was also a question as to whether or not the child really did have severe allergies. And of course, the child had no reaction to whatever had occurred. So, but I do want to mention one other thing. So Chris said something about, trying to think in his conversations about what he was talking about, how he was handling his child, there was something that came to mind for me. So a lot of these serious situations with whether you call it restrictive gatekeeping, parental alienation, you have a mental disorder, at least on one side. And a lot of times that can be borderline. It can be narcissism. It can also be borderline personality disorder. There is a great book out there, and we should put this up so people can see it. It's called Stop Walking on Eggshells. And it is a book where the first 100 pages teaches you everything you need to know, because it teaches you about all the tactics of a borderline, all the things that they do. And of course, they don't even know they're doing them because this is just the way their brain works. So you cannot be rational with them. But if you understand what they're doing, you can help understand how to respond to it. So one of the things with the borderline is called object constancy. Okay. Yep. Sociopath. You're right, Jake. All right. So I'm going to read this to you. I pulled up the definition, and then I'm going to talk about how it plays into this. In object relations theory, the ability of an infant to maintain an attachment that is relatively independent of gratification or frustration based on cognitive capacity to conceive of a mother who exists when she is out of sight and who has positive attributes when she is unsatisfying. Very important. Okay, so let me play this out for you. You have a baby, you have a little baby, 4-month, 5-month-old, 6-month-old baby. Rock the baby to sleep, baby goes to sleep. You go in the bedroom, you lay the baby down in the crib, you turn and you walk away, baby cries, right? You go pick the baby up, hold the baby, rock the baby again, lay the baby down, turn and walk away, and the baby cries. It's because the baby cannot identify, if you are not right there providing gratification and satisfying, soothing stimuli, the baby cannot understand that you continue to exist. You're just someplace else, and that relationship is going to continue. And, and there'll be other moments, and you'll get back to that place of gratifying and soothing contact. So a borderline gets stuck in that. And this is one of the reasons why they withhold children, because they cannot perceive that their child can remember them. Honestly, this is honest, okay? Because this is where their brain is stuck. So they cannot conceive that their child will even remember they exist if their child is out of their face and out of their life. So that's very important.
Which is why they want primary care and just weekends off with dad, because that allows that makes them feel like the child.
Right.
You know,
and plus, it also, even that weekend is incredibly distressing for somebody who lacks that object constancy. It's incredible distressing for them. So I don't know what she does on the weekends when she's free, but a lot of times you'll find situations where those types of parents do some, they do some things that are self-gratifying, extremely. I mean, whether it's drinking or partying or, going out with crazy guys or whatever, but they will engage. Yeah, they will engage in some extremely gratifying things to try to soothe that in their brain. Another thing about a borderline is chaos. So a borderline thrives on chaos because that keeps the attention drawn on themselves, right? Because if there's constantly chaos around them, all the people around them have to feed that chaos to try to fix it, right?
Like medical issues.
Yeah, but chaos, just chaos. And so if you're dealing with somebody, who's doing that, you have to constantly measure that you are not reacting to chaos. So, just like Sean said, where there should have been some conflict de-escalation activities instead of conflict escalating, a person who's a borderline personality can't do that because they don't have the ability to do that. Can I get, but wait a minute, per continuous education credit for watching? Yes, you can.
Yes, you can.
In Cash's case, we had that. I was comparing his ex to the eye of the hurricane. Is that Cash? I mean, Cash has had his case public for 5 years. He was one of the most well-known activists, and she gets on the stand, and we asked her like, "Well, Julie, have you ever been impacted? Has anyone ever walked up to you in the street? Have you ever been approached in the grocery store? Have you ever had anyone walk up to you at school or anywhere? No. Church? No. But so she's in this total isolation. No wind is touching her, but all hell is breaking loose around her. And she doesn't care. She doesn't care how many cops, counselors, supervisors, judges, attorneys, the general public, the electors. I mean, it's a crazy. That seems to be what you're describing a little bit there, Connie.
Yeah, for sure. Exactly. I mean, that there has to be a certain level of chaos so that everybody's responding to that, right? Mm-hmm. So those are two things. And then, of course, there's gaslighting. Another thing that they do is changing the facts to fit their own reality. And I'll tell you, the first time I read that, I said, I never knew a liar. I became a lawyer late in life. My family had a restaurant business. I spent 25 years in the restaurant business before I ended up going back to school, became a lawyer. I was in my 40s before I started. But, I said, I never knew a liar until I became a lawyer. And there are definitely two types of liars. There's a compulsive liar and there's a pathological liar. And so a compulsive liar is one who just says whatever sounds good at the moment, right? It's a compulsion. So, if you say to somebody, oh, why don't you come over tonight and we'll have tacos? Do you like tacos? And they go, oh, I love tacos, even though they hate tacos, right? I mean, that's a compulsion. It's like there's no thought there. And then the pathological liar, though, is a little bit different because the pathological liar truly, truly believes what they say is true. So, if you say, I saw you yesterday at at the store, picking up some food, and you were with this strange looking man or whatever, and they'll go, I wasn't there. That wasn't me. Right. And they can truly believe that, and they can walk into that realm and truly believe it. So a borderline personality can change the facts to fit their reality. They truly have that pathological sense. So
Sean was on to something about this, about controlling his client. And this sort of feeds into where Connie was. I know, Connie, you have to go pretty soon, but you're right in the heart of cluster B personality disorders. So cluster A is usually associated with paranoia, perception difficulties, schizoid personality, those kinds of, that's one subset. And then cluster B is the big four, which you just touched on: narcissistic personality disorder. Borderline personality disorder is probably as much or more important and hardly understood, which you're just explaining. But there's two more. There's antisocial, which seems to be lying, right? I mean, a lying under oath is a crime. And I'm not a psychologist, but just basic understanding. But the third one, the last one, the one that I think is not adequately discussed and understood, is histrionic personality disorder. And how does an attorney deal with a client who's histrionic? They're feeding into their wallet. It's just like the gift that keeps on giving. Right. When does an attorney come in and put the brakes on that? And Connie and Chris and Sean, isn't what Chris's ex is doing here just a flagrant episode of histrionic personality disorder, creating panic? Emergency room. Always a panic. Isn't that what's happening right here?
I can't see it. What's it say?
Rules of, what does it say? Professional conduct. Washington Rules of Professional Conduct.
Yeah.
Yeah.
Are you about to read something?
I'm just looking it up here because there's an answer to your question, which is the client with diminished capacity. Right?
Yeah.
I mean, I'm all about the lawyers and the ethical rules and the fact that they're not being enforced, that our colleagues are out of control. And,
yeah, but wait a minute. People who have a personality disorder do not consider themselves a person of diminished capacity.
Yeah, but that's the rule reads. I mean, I'm a personal injury attorney. I've actually had a client that had diminished capacity, and I was required, even though he was able to make a lot of decisions on his own, and he presents extraordinarily well, I had to step in and act to protect him because I was recognizing that what he was doing was ultimately self-destructive and harmful to both himself and to his own case. And when you read that in Washington, it's RPC 1.4, right? It says that when the lawyer reasonably believes that, doesn't have anything to do with the client. If the lawyer reasonably believes that their client has one of these issues that's driving what the decisions that they're making in the case, it's the lawyer's ethical responsibility to step in and act to help protect the client against making these decisions that are going to ultimately harm the client long term.
And in a domestic case, that's when the lawyer sends you an email and says, I don't need your services anymore. So, especially cluster B, narcissism and borderline and histrionic and pathologic and sociopath. Yeah.
Well, the other thing that we're not talking about too here, which we've sort of danced around, and Ted kind of on it, which is, this old phrase that clients find their lawyers. Crazy clients find crazy lawyers.
Yeah.
We don't talk about the fact that there's, that our profession, has an overexpression of some of these same personalities that we're talking about that drive, the way the litigants are behaving. I mean, here's the dirty little secret, right? The American Psychological Institute or the American Psychological Association, and even the ABA both admit that, the law is the second leading profession and employer for people with antisocial personality disorder, for sociopaths and psychopaths, right after CEOs.
Yeah, but to attorneys, I can usually say something like, "What are you doing? What are you doing? Is this really where we're going to go?" I mean, I have of course, a lot of the attorneys that I work with now, I've known them for many, many years and had, a few cases with them. I'm having a lot of trouble with the millennial kind of age attorneys, the ones who are, I don't know, 40, maybe just going into 50, but those 40-year-olds, they're a very strange bunch. I'm having is that you?
That's these guys.
How do you fit? Do you fit in okay with them? Because I'm finding they're very odd. And
No, clearly they're on the show with us, Connie. They don't fit in well at all.
yeah.
I'm just trying to run the boomers out as fast as I can, Connie.
I know you are. And you're going to be sorry when you do. You're going to be like super sorry. All right, you guys, I have had a really good time and I am going to go to bed because it is past Grandma's bedtime since these boomers over here.
Thank you, Grandma.
It goes along with it. So, it's 10:40. Girls got to go to bed.
Thank you for joining the conversation.
I really enjoed it. It was good to see all you guys.
Connie, today is National Beer Day. So,
I think I'll go find one before I go to bed. All right, y'all. Good night.
Good night, Connie.
We're maybe, Sean, I want to ask you a question. We can wrap this up and get back to Chris a little bit. But could you ethically represent a cluster B personality?
Could any attorney represent a cluster B personality?
If you had someone come to you and said, "I've filed 4 CPS cases against this man. I've filed 35 police reports, and let's say like her name is Erica Bush, would you be willing?
Sounds familiar.
Would you be willing to could you ethically represent someone like that who you believe that is incapacitated?
Well, you know what? I think that's a really interesting question because I think that really is an interesting question. So on one hand, right, that person deserves and has the right to access the justice system and to be able to get an attorney to help represent them. So on one hand, absolutely, we as attorneys have a responsibility to be able to take that person or to be able to help them with their issue. On the other hand, right, that person who is going to show up in your door, and it's interesting that you should give this example because my unethical opposing party, another case that I've researched, her client has filed over 40 false and frivolous police reports against her ex. Literally every single time they see each other, picks up the phone and she literally makes up some story, whatever. Okay. And then when you go back and you research through opposing counsel's, previous litigation history, it's pretty clear that what she does is she instructs her clients, call the police every single time you have any interaction with your ex. So, okay. So that client absolutely exists. So the problem then becomes not, from the profession point of view, my take on it is, it's not that the fact that there are these people that have these mental health issues, that they may be diagnosed or undiagnosed or whatever. But when they show up in front of the attorney has an absolute responsibility to be looking at these ethical rules and making sure that when that client is asking them to do something, like escalate the situation when it's unnecessary, like what's happened for Chris right now, okay, or B is presenting visions of facts that don't hold together, and the attorney doesn't investigate them well enough, right? When they're doing some of these activities that we see unethical attorneys do all the time, it's not just about the litigant and their mental health issues or whatever they may be. It's about the attorney not following the ethical rules to ensure that they're pursuing their client's case in an ethical manner that doesn't abuse the other party, that doesn't abuse the justice system, that actually helps them find a resolution for their issues. And this is why it's so important, because if people like that have those issues, if they got a brick wall of attorneys that were like, I'm sorry, that's unethical, I'm not going to engage in these behaviors, their behavior would not get the forum that they want.
You want to
And
know?
that's the true problem, is that you and I are gatekeepers. I mean, the ABA says that attorneys are the front lines and gatekeepers to the judicial system. And if we don't practice law ethically, if we don't follow these rules, if we don't say, whoa, this is a client that's got a problem, it might not be diagnosed, they might not even know they've got a problem, then what happens is exactly what we see.
Well, I'll just tell you a little bit of my own story from my own personal experience, because what you're telling me actually happened in my own case, where, and I'll tell you why this happened. So my ex-wife's first attorney in May of 2018 came up to me and my former attorney, and she quit. And she said, I can't take this case to trial. She told that to me and my ex-attorney quitting, telling me and my attorney to our face that she can't take this case to trial, meaning, to add a Sean term, she cannot ethically take this case to trial because she knows that my ex is a total liar. Okay. Now, how can I get that in? Okay. How can I get that in as evidence? Because that's actually great evidence. And what I think led to that is that she was constantly keeping the kids away from me every chance she could get, was hysterical with her first attorney. You know, the guardian ad litem on my case has said that this woman's hysterical. She's hysterical. She's called the police 40 times. And I think what happened in that case is that, you know, she accused me of pounding on her windows at an intersection, when in fact I was just trying to find out where my kids are. Okay. I went up to the back of the window like this to see, and then she was on the line with 911, recording it in her speakerphone, and alleged that I was pounding on the window, scaring my children at an intersection, when I'm looking to see, because she was supposed to be taking the kids somewhere, she wasn't. Well, I FOIA'd the 911 call, and it was hilarious. I mean, there was no pounding on the window. I mean, it was just fake. But I think this attorney dealt with this over and over and over and over and over again, and that she finally tapped up and had enough, because she probably knew how much perjury would have been suborned by her in a trial. And then the next people that came around had absolutely no ethical scruples at all. I wasn't a big fan of this woman, but this woman actually had enough. I mean, she was doing her job, trying to represent her client, but she knew that in fact, you know, when she got in too deep and had to get out.
So yeah, you know, you're right. And you see, we've talked a lot about this, right? Both online and offline, right? You know, Rudy Giuliani was just suspended. Yeah. Interim suspension, you know, prior to even the hearing and the discipline, he was suspended because he violated RPC 3.3, making false statements of material fact to both the tribunal and to the public. Yeah. And the danger for the attorneys that take these clients and that just believe hook, line, and sinker whatever storyline it is that they say, and also warp what it is that the client believes, is that they're going to wind up in exactly that situation where they're out there, they're making false statements of material fact. They're doing it on the record. They're lying to the court in either motion or in oral argument, and they're literally playing Russian roulette with their own law license.
Well, they should, but I mean, I'm going to give you the converse of this, and I want to find it, because this actually came in today. This is I have a ARDC complaint against me now, an actual complaint, and this is the first allegation. I swear to God. Okay. This is the first count of my complaint. This is what I allegedly said to Judge Carr on October 21st, 2020, in an email. Okay. So this is what I said in an email, and I'm getting charged with this, and the count is here. This is false and or reckless statements about the qualifications or integrity of a judge. This is what I wrote. Judge Carr said late September, I do not agree. This is child abuse perpetuated by the court and its corrupt and incompetent officers. Okay, I'm complaining about the fact that my appellate court order remand hadn't occurred, that they're breaking an appellate court order. Okay, so now I have to defend it. This is child abuse perpetuated by the court and its corrupt and incompetent officers. Okay, I'm talking about the guardian ad litem who's stringing this case out, the opposing counsels that are suborning perjury. But what they're really going is that I have to defend the truth of the statement that what these people were engaging in is child abuse, which is what they are, which is what they have, and which is what they've done. I mean, the crimes that these people have committed against me and my children are beyond. And the truth is that I didn't call the court corrupt. I said the court, its officers, the people around the court. You know, apparently they couldn't tell the difference of that. But am I gonna walk that back? No.
I don't know. I mean, it seems really, really odd in our profession that there is this bizarre belief that courts never become corrupt. People involved in, attorneys and GALs and all of the circle of people that surround these cases, that they never become corrupt, that there's no such thing as that ever happening, and that when you suggest that could be a problem, then somehow it's a reflection that you're actually the problem. If you open up the news, right, you see, I mean, just today, I'm not sure if it was Chris who posted it, but I saw somewhere on Facebook, a judge who is getting, criminally charged for corruption issues, right? I mean, you're looking at what's happening in Los Angeles with, Attorney Giraldi, right? And the California State Bar has just acknowledged that a decade of screw ups related to bar investigations against him. We're seeing in my case in Washington, right? I keep saying, there's this problem with my opposing counsel, and it's a pattern of behavior that goes back 10 years, right? When you have this sort of acknowledgement that on one hand, we all know wherever money exists, corruption can follow, then there's this myopia that, if you say anything that this might be an issue of corruption that we should pay attention to, somehow that's a reflection that you're disparaging the court or the judicial system.
Well, I have a case who is also a woman who has Judge Carr, another one. Okay, and again, this Judge Carr is out with a brain tumor. Okay, he's about to have brain surgery. Okay, so everyone's asking, and this is something you might not know, Sean. How many cases, and if you search for cases of judges having brain tumors and courts dealing with, well, what do you do? What happens? When did he become incapacitated? When was his judgment impaired? When was his perception impaired? When is basically everything that he did tainted by an incapacity of the brain? That's what we're dealing with right now. But I'll give you an example.
I don't know.
No, it's never happened. I've looked. I just spent, some of yesterday looking at this. It's never happened. But I've got several cases where people are dealing with this. And I have a woman, okay, a client who contacted the FBI, Chicago field office of the FBI, and made a complaint that she was getting extorted. Well, it just so turns out that they took the call, called her back, and then talked to me. And I talked to them for 90 minutes. Well, what got the FBI's attention was a specific pleading that happened a few years ago. And so my client gives that same document. Okay, we write up all the corruption that happened with the guardian ad litem in this case. It's child representative, actually. And we send it to the ARDC, and they do nothing. So she starts a criminal investigation with the FBI, but she can't even get the ARDC to open it with the same evidence.
I don't know enough about attorney discipline to be able to understand, how that works. But I've followed what happened in Los Angeles with real interest, because I'm like, this, because partially because it's so obvious and so clear, right? It's really disturbing that, an attorney that is able to cultivate connections within a bar association is able to escape discipline and justice. It's able to escape discipline. Maybe justice is too strong a word, but they're able to escape discipline for decades. Oh, yeah. That other attorneys get sanctioned for. And in any other situation, if we had a regulatory body that was looking over people, and that situation existed, we would say that's a real serious problem, that it might actually be evidence of a much bigger problem, corruption, who knows, whatever.
If this was the medical field, it's like malpractice. If this was the medical field, it would be considered malpractice.
Yeah, we deal with this. I mean, I don't know of any profession where you're not allowed to criticize the attorneys. Like we're not literally not allowed to criticize the attorneys and judges when they cross the line.
Right. Any profession where you're not allowed to criticize your own profession.
Right. I mean, because look, everything, like a banker crosses the line into money laundering. A musician crosses the line into playing Nickelback. There are all kinds of,
copyright infringement would be like a musician.
Copyright infringement. Ripping songs off. That's great. Thank you.
I had to correct you.
Right. So, but for an attorney to say, wait a second, you people have crossed the line, and you call them out on it, and then all of a sudden they're attacking you with sanctions motions. Like in Cash's case, we have the counselor sitting in the courtroom. He's watching this, and the hack attorney, and I'm going to say this because he's a hack. Raymond Bolt's a hack, okay, as a mercenary, okay. He goes to the judge and says, Your Honor, we need to have the children escorted in by security because they're afraid they may see their father. Okay. And so the doctor is watching this and his jaw goes,
yeah.
Meaning you can't be serious. That's traumatic for the children. That makes the children more uncomfortable. Like that's like what warning, like the parent shouldn't be standing outside the door.
They're feeding the same alienation by doing this.
Did you see Divorce Corp, the movie?
Yeah.
So, okay. Do you remember that scene in the movie where they talk about this guy who disparaged his judge, disparaged the court and disparaged his judge, and he wound up getting sentenced to jail, and he was in jail for, I don't remember, maybe he was sentenced for a year in jail or something like that, and he would have to tell people. They were like, what are you in for? And it'd be like, well, I badmouthed the judge, and then they're like, wait, I'm here for armed robbery or whatever. And you're here because you said bad things about a judge. And it wasn't until the movie came out, it created some political pressure behind it, that suddenly miraculously the governor in the state, was able to commute this guy's sentence. He was able to get out of jail. So your point about the idea that, this seems to be singularly unique, that that our industry, that we can't actually criticize what's happening inside of our industry. We can't criticize judges or the court or anything or anyone related to it, because somehow that brings the judiciary into dispute.
And it's always punishing the whistleblower. So,
but the question that then begs is, how do we self-regulate ourselves? What does that mean, that we're conceding the job to the media? That it's only when the media reveals those issues that suddenly, can anybody talk about that? I don't know the answers to that. That's not it's why the part of, but
it's why the bad people usually win in family court, and the people that fight uglier and dirtier, because if they cross the line first and you blow the whistle on them, they're going to attack you. So what I wrote in Cash's case, when Raymond, he makes this oral motion, then he turns it into a written motion, and the judge grants it before I have a time to respond. He files it in an afternoon, and the judge grants it that evening before I even had a chance to respond and say, no, you're smearing my client and you're scaring the children. I wrote a line on a response that was effectively mooted by the order she had already entered. But
you're exactly right about that. I mean, even in my case, my research into opposing counsel has shown that every single attorney opposing party that she's opposed, I could be wrong about this, I could be a little bit off, but it certainly looks like every single attorney opposing party has miraculously had bar complaints filed against them during the course of the litigation. So, that you're exactly right. This idea that, if you call them out, right, and you say what you're doing is wrong, what you're doing is unethical, you're lying, your client is lying, they lied about this, right, whatever, then they turn the tables and they go after you. Yeah, that's exactly the case.
This guy's accusing my client of abandoning his children, basically all forms of abuse. So we're basically calisthenics. Just lie after lie, harassing him with contempt petitions on fees and things that he knows that my client can't afford. Okay, yep. Just absolutely abusive, harassing. And then this guy is coming in as if he knows something about this and scaring the crap out of the children, smearing my client. My client has no access to his kids. It's totally unfair to begin with. And then in front of a counselor who's appalled, and I'm supposed to turn the other way on this and say, wait a second, this court should be listening to actual experts. And this is what I wrote in a response. Right. Not hack domestic relations attorneys like Raymond Bolt.
Well, right. It's a deliberate strategy of tell so many lies, create so much chaos, so much confusion, right, that nobody can no judge, nobody can come along and successfully unpack that. And they cannot sort truth from fiction because there's just so much fiction.
So they err on the side of safety and precaution.
Right. My unethical opposing counsel, I'm literally going to quote from a Court of Appeals brief written by another attorney who opposed her, where he said that opposing counsel's client, all right, that the only evidence that she has of domestic violence is that she's come into the court and called him a domestic violence perpetrator over and over and over again. Right. So when you find that out about your opposing counsel, reading the briefs for other attorneys from previous cases, that shows you that it's an endemic problem. It's exactly that. It's create so many lies, so much chaos,
doubt,
so much confusion,
fear.
That fear mongering. That no judge coming along and trying to pick up the pieces, trying to sort this mess out, can figure it out, and they're just like, well, I just give up.
And so let's bring this back to Chris's situation.
And Sean has to go soon, so let's wrap it up.
Yeah, let's wrap. Well, this is a perfect way to end, and we can because this goes right into Chris. We should.
And guys, thank you everyone who's been watching and participating in the chat.
Thank you. This goes particularly to Chris. Okay, the opposing counsel signed this filing, right, to take away your time with your kids. Okay, He has no idea what he's doing. Connie was right. He never contacted, and Sean was right. He never contacted you saying, "Hey, what's going on here? Can we find a resolution to this issue?" No, never does that. He's engaging in histrionic personality. Him and his client engaging in histrionic behavior. They're almost certainly lying to the court and causing abuse on the children, making him a child abuser. Okay. And they're telling you, Chris, that you can't come back like Donald Trump did, counterpunch, and go back as hard on these people as what they're doing to you.
Because they'll tell me I need a psych eval.
Tell me why. Sean, I can't figure it out. Why can't we attack these people that cross the line and destroy and denigrate our profession and make everyone hate us? Why can't we call these people out?
Yep.
Well, we can, and
we are.
and we're doing that. I mean,
and it's up to the viewers to be sharing this and getting their friends to share this. That's how this works.
I don't know. I hope. I mean, I have a certain amount of faith in the fact. Let's be hopeful about one thing. Giraldi in California has gotten away with just unbelievable stuff for a couple of decades, and he played on his career, and he played on his star power, because he's the attorney from Brockovich, but all that is caught up to him now, and the Bar Association in California is on a cleaning house expedition. They're really trying to clean up their act, and they're investigating him very seriously. New York State took pretty seriously Giuliani's behavior. So I have a little bit of hope that with attorneys who are willing to stand up and say this behavior is wrong, this behavior is unethical, it violates these rules, and starts holding other attorneys' feet to the fire, and say it publicly that maybe we're
fighting against these people, and we're trying to educate. We're not getting into fights because we want to. We're trying to educate these people, like Judge Christensen in Lake County, that should know better.
Do criminals want to be educated though?
That you're that you're engaging in child abuse. We're coming in with this.
Hang on, Chris. Hang on. I don't think that's completely fair. Okay, I don't think it's fair to call a judge, a criminal who actually isn't a criminal. I don't think it's completely fair to say that that the judges are engaging in child abuse, because that's I don't think that's fair, because what I really I went to law school because I was interested in issues of justice. I bet you so did you, Ted. I'll bet you 99% of our colleagues did as well, even the ones that wear black robes. And I really believe that what happens for them, is that there is this handful of unethical bad apple attorneys that magnify the impact of their cases on everybody, but also that the people who wear black robes don't truly understand what it is that they're dealing with.
No, they don't.
And I think the good news is that I think that is starting to that hidden problem is starting to come to the surface, and you're starting to see that there is much more of an awareness about it. And if that were not true, you wouldn't see that the domestic violence industry on the other side be backlashing against the fathers' rights movements, calling us sexist, calling us misogynist, saying that parental alienation is junk science, attacking the people who are doing, actual good science, like Jennifer Harman, right? She comes out, peer-reviewed, hard science, hard social science, and, then they attack her. There's starting to be much more of an awareness that the judiciary needs to really pay attention to these problems. I mean, Bill Eadie, who's an attorney and a social worker and the founder of the High Conflict Institute, right? Wrote the book Splitting about, narcissistic and borderline personality disorder personalities inside of the judicial system. And his book is used in judicial CLEs, in judicial training conferences. It's used as the textbook. So, I don't think that it's hopeless, and I don't think that it's fair to say that these people are child abusers or that they're criminals. I think that they simply don't recognize what it is that they're looking at. And in fairness to them, this is a very difficult problem to understand and see. I mean, these people people with BPD and NPD, they present extraordinarily well, right? They say all of the right things that trigger the court to want to protect.
Sure. So I agree with what you're saying, Sean, until the point that attorneys like yourself or pro se litigants like myself or Ted Bush goes in there and goes, all right, well, you don't understand it, so I'm going to show you, and I'm also presenting you evidence that there's something going on here, and they ignore evidence. That's where I say, okay, they're ignoring facts.
Yeah.
So it's not that they don't understand, because he's making you understand.
I mean, perception is reality, and I'll tell you what I saw in Lake County the last 5 days in that trial with Cash. Not the slightest clue, not the slightest interest. You know, Joshua just posted again. I saw his last message. He was dead on. Okay, they don't know. They don't know what is child abuse, and if someone doesn't tell them, and you have to tell it, you know, Your Honor, this is harmful to children. You know, then that's only going to get you so far. It's like, no, wake up. You know, this is child abuse. You are scaring these children. They're already scared enough. You're bringing them in with security, and you're legitimizing. You're predetermining and legitimizing what is ultimately the ultimate fact question in this case of whether these children are scared of their father.
They're not educated that their system is traumatizing the children.
The state is telling them that you need an escort. When all the worst thing that their father's going to do is run up to them and give them a hug.
Or just say hello.
I miss you. They're preventing the normal human communication, the normal human bonding. They're preventing the reunification counselor from meeting with the kids. So I'm sorry. Like, I hear what Sean is saying. I hear what Chris is saying. My view is that when these people screw up, it's child abuse. They're making all this money. They're getting paid an enormous amount of money. They don't know federal law. They don't know. There's all kinds of law they don't know. They don't know.
Wait. Let's be accurate. When they screw up, it's not child abuse. It's facilitation of. It's facilitating someone who is abusing a child. It's a nuanced distinction, but it's important. And we're a profession of.
You're an accessory. It's like being an accessory to murder. No.
It's accomplice. It's accomplice liability.
There's a term for it. There's a term for it. It's called judicially enabled parental alienation.
Sure.
Okay. That's what's going on.
But that's conscious.
That's the point that you're really trying to make. And that's the term, judicially enabled parental alienation. And when they don't know, you see, here's the real problem for those judges is this. Okay. It's the quintessential problem of you don't know what you don't know. And the thing that you don't know is the thing that will really come back and bite you. If I'm going to start practicing in admiralty law, I know I don't know much about admiralty law. I'm going to go read all the books on admiralty law. Fine, right? But the thing that's really going to screw me up in admiralty law is going to be the thing that I have no idea that I don't know about it. And so I'm not going to go research it. I'm not going to go find out about it. These judges don't, many of these people that are involved in this thing, first of all, they're being actively deceived by unethical bad apple attorneys. They're being deceived by people who have mental health issues, and they might not even know they've got a mental health issue, but they've got a mental health issue, and it's driving the way they're behaving, and they're behaving in a particular way that sends all of the danger signs up for the court, and the court wants to protect them, and the court does not understand these things. And the reason they don't understand it is because we're at the beginning of this movement on it.
And that's true, Sean. But again, it reminds me of John Kerry, his famous quote to the Senate Foreign Relations Committee, I think it was in 1972, is, who wants to be the last one to die in this war? I mean, you're a client, you're getting, your life is being wrecked. And how long are these clients like Chris going to wait for these people to get their shit together?
Right. Now, I know more than they know. You guys know more than they know.
And I mean, to experience, because this is so frustrating for me. I mean, and I probably not even supposed to say that these people have no interest in this. They have no clue what they're doing, but they don't. Like, you're looking at them and you're like, you're kidding me. Like, you're not even remotely interested in making sure that you're not scaring the pants out of these children and prejudicing this entire trial by basically presupposing their father to be a risk to them without hearing any evidence. And I'm supposed to let that go.
Right.
And I'm supposed to let the attorney that's engineering this, who knows nothing about any of this psychological, behavior and issues, and what all the experts are saying. Okay, we don't have any experts in Chicago and Lake County for the most part, not the nationally recognized ones, the ones that are really take this seriously, study, that are part of the parental alienation study group, the real sort of, we might have one I've heard, but I don't think so. And so we're in a desert out here in my area of Illinois, and there isn't even the slightest interest in what the people that spend their lives studying this are recommending. I filed text messages from Dr. Richard Warshak into some of my cases, including Cash's case, where they're talking about the importance. There are a number of things about keeping in constant contact with children. The courts will say, no, we're not going to have any contact with the children, when the experts are saying even a healthy attempted contact is the best thing for them. So the courts are getting it exactly backwards, and they don't want to hear from these people. Like,
look, Ted, I know, trust me, I feel your frustration. I do, because, I've gone 2 years without seeing my son, and over and over and over again, it's like talking to a brick wall. My judge in the family court, in the family case, does not seem to get it. She either doesn't get it or she doesn't care. I'm not sure which one it is. I hear your frustration. I completely get it.
The three of us are living it. So
right, we're right. I don't know. I think that the only thing that we can do, right, is continue to push and to continue to advocate and to continue to try and educate. And it's interesting you talked about Warshak, because I don't know if you've read that article in the ABA. No. I'll send it to you. All right, but Warshak's in it. So I think that's really the only thing that we can do, in addition to the fact that at 9 a.m. on Parental Alienation Day, right?
Right. Plug it.
We're gonna be standing in front of a courthouse with our little cardboard sign talking about parental alienation. You just got to build the movement, right? I mean,
yeah.
Every social movement in this country winds up in the same sort of situation.
I guess, Chris, I mean, we need to talk, more. I think Sean and I, maybe sometime over the weekend, we can do another one of these where we can go through your case, give it the proper attention. I mean, we have someone like Connie Reguli on here. We cannot miss the opportunity to go through and get some really high level experience.
This entire conversation was great. I got a lot of good feedback. I mean, you guys are educated. I had 3 attorneys on here from different states, from different regions of the country, talking about cases, 2 of which you 2 are going through your own personal family law cases where you haven't seen your children, and are basically have admitted on live air that the systems, whether you want to say it's broken or it's designed that way, or that the judges are uneducated, or whatever the fact is you guys are saying the laws are being broken because you're presenting it, and they're saying no.
I want to go further than that, and I want to make a declaration, because I've basically made up my mind. I mean, I've been leaning this way, and I've made up my mind. I'll just give a quick story of what I did before I did this, okay? I was a lobbyist in Washington. I met with all members of the U.S. House.
Sean, we'll see you later.
Bye, Sean.
Bye.
Bye.
I was a lobbyist in Washington, D.C., and I called out. I mean, we were working with some manufacturers, basically trying to avert what became the 2008 financial crisis. Mm-hmm. And we were working with the Senate Finance, Senate Banking, House Financial Services Committee, to try to fix our trade laws and our dollar policy, to make sure that all our, Midwestern Rust Belt, communities didn't fall through the cliff. Okay. And then guess what happened? Then we had all the foreclosures in the Midwest, which trickled into derivatives and all the things that AIG and all the the cascading financial impact, which became a financial crisis, which was really the loss of jobs, wages, and homes. Mm-hmm. And we were trying to communicate with these people and explain to them, like, you can't turn the other way on these cheap Chinese imports at Walmart and Home Depot and Target. and all these people really like, because it's going to destroy our economy. We're telling them this. And they just listened. They were so arrogant. They were all bought off by Morgan Stanley and Bank of America and all them. They were all, getting ready to work their way up. And then we had a financial crisis for exactly what we were telling them for years.
Right.
And so it's the same thing that applies here, is that their system is burning down. It's crumbling in front of their face, and they're too sheltered to know it and see it.
Right.
So if it means that someone like me and others is going to have my hair on fire and then be telling them that, sorry, it's over.
Yeah.
You have to change. You have to change now. You're hurting families. You're hurting children.
And it's clear. We have the data, and it's proven.
Chris, your kids aren't with you tonight because
no, they should be.
And the judge who entered that EOP should be ashamed of himself. And I hope he watches this.
He might.
And the attorney who did this. I hope that they know how many people are watching this.
You know what? And maybe this time he won't cherry pick my episodes, and he'll play the whole thing next time instead of picking out a biased segment from one episode.
We can go into this later, but what that attorney did, and I would tell this attorney's name right now on your podcast. What he did to you through your having Larnell Palmer on this podcast, wearing his hat, that was race baiting. That's the same stuff that happened with Jesse Helms, running for Senate in North Carolina back in the 70s and 80s.
I mean, he handpicked the most derogatory. It's not even the name of my podcast. That's a guest, and he didn't listen to what we were talking about. It was the fact that it's called F child support, right? So none of the information was shared. He just found the one segment that basically I was derogatory about the court, which it's not derogatory about the court. I'm living it. You guys are abusing me.
You were talking to an African-American man
I was talking to an African-American man,
on the south side of Chicago. Okay? I'd like to see how these people make it on the south side of Chicago. That was a dog whistle. That was racist. I mean, if you want to file a motion for reconsideration in your case, you should. Oh, what they did is that was race baiting. That was dog whistling. That's the stuff that they always hear that's happening before the election, going back years and years and years. They are trying to divide us from our allies. They're trying to divide us from men talking to women and Caucasians talking to African Americans and Hispanics.
It's not going to happen.
And Asians. What they did to you was with that, by bringing your podcast in and focusing in on your conversation with an African American from the Southwest side, a great person, Larnell Palmer.
Yeah, smart.
Shame on him.
Yeah, and like I said, he cherry picked it. He could have easily played my discussion with Jennifer Harmon or the clinical psychologist or my representative of North Carolina in my district. That's the interview he should have shown. But he wanted to portray my podcast as this negative, disparaging thing about the system when I have experts from, I had a child support agent on there saying, yeah, we're destroying families. He didn't want to share that. So yes, it was a completely cherry-picked, biased tactic. And honestly, if he was a better attorney, he probably actually would have had an argument, but he's not a good attorney. And he didn't even have any. I'm being kept from my kids just like Cash is, because after about 6 months to a year, I started figuring out, all right, well, the courts aren't helping me. What do I need to do as a father, as a parent, as a man to advocate for my kids? And I'm sorry they don't like what we're saying, Ted, but it's true. So maybe take a look at yourself and get a psych eval.
I mean, the harder they push, the deeper, I mean, they've already made a lifelong enemy of me. Okay.
Yeah.
And Cash.
Yeah.
I'm not sure whether they're there with you yet.
They'll have their opportunity to correct their mistake.
Yeah. They still have an out with you. They need to watch out because, there are so many people coming through this. People like Greg Ellis. I contacted Greg Ellis. Yeah. People like Britney Spears, people like Cash, people like you.
Yeah.
They're indiscriminate. they look like it's like an assembly line. And when, one of the toys in the assembly line has a real bomb inside it and is going to go off on you because you screwed up.
Right.
It's going to keep happening, but this system is breaking down because these issues are so trivial and so unworthy of a courtroom that it's going to flood over, and the system will break itself. It's just a matter of time. So
they want us to stop talking, and they're going to keep us from our kids until we stop. And if you keep me from my kids, I'm only going to get louder. And the louder we get, the more these people that are chatting with us and that watch this and share this, they're going to start talking too. So there is no other end for the family law system but to crumble. Yeah. Period. It's coming.
It is happening right now.
Yep.
It is happening right now. It reminds me a little bit about the Matrix, of people falling through the cracks and getting out and seeing what it really is. That's happening, and social media is a lot like your show is allowing that to happen much faster. And if you increase the cycle, the education rate at which people come in, I figured it out in a couple weeks.
Yeah,
I knew right away that this was a scam. But the faster that we can educate people, the faster we'll be able to get change, because the people that are engaged are when they're impacted, and to get them up to speed and to fight back on these people, attack these domestic relations attorneys.
Right?
How dare they think that they're incapable, that they're immune from criticism? Are you kidding me? I get it from pro se fathers. I represent some women, and I've got these pro se fathers, insulting and demeaning me all the time.
You're not suing them.
I don't give a shit.
Yeah, say whatever you want.
if you want to be like that, there's literally nothing that these people can say to me that I haven't already heard, and that I'm not going to fall for. So, these people are hiding behind their own incompetence, their own malpractice, and we're not going away. And we're going to keep talking about your case.
And the more we talk about it, the more other people are going to feel comfortable talking about it. And
I'm okay. I'm sure Sean's okay for doing a part 2, but we really do a forensic analysis of your case and how you got to where you are. But at least what you were able to do tonight, Chris, is to get so many issues out. Yeah.
And I had 3 amazing people and attorneys on here who do this every day, speak about the real issues. So that's what this is about. Guys, share this broadcast. That's how we make change. We gotta change things as soon as possible.
We all gotta group together. Okay?
Yeah.
It needs to be a nucleus. I mean, great shows like Dad Talk Today, whatever. We the Parents Podcast.
Eric Carroll, if you want to reach out, man, you want to get together and do this. I've reached out a few times. I know we've had some differences, but I'd like to put those aside and talk like men and maybe combine our efforts, because that's how we're going to win.
There's more, and that attitude has to apply to everybody, to men.
Yeah.
Women. The way we turn this upside down is that
mothers, fathers, stepmothers, stepfathers, grandparents,
girlfriends, boyfriends.
Get behind the people that you know and love that are being abused. Your grandchildren.
These people, and get loud.
Exactly. Ted, thank you so much.
Bye-bye.
Let's talk soon, and we'll chat off air. But guys, thank you so much. Have a great night.